Not really into that kind of stuff. About ready? People are filing in. I guess they're going to make it. I don't know.
It did not actually.
You didn't get it working?
Nope.
Okay.
I don't know why we downloaded the app and then we couldn't really connect it with it Bluetooth wise. So I don't know if it was like not charged or something.
Or the batteries.
Yeah. So
Okay. I wish I'd known. I would have given you more batteries. Okay, you ready?
We ready?
We're ready on this end.
All right. I'm going to start with roll. Mustafa. Mustafa, you here?
Yeah.
Yep. Okay. Let's see. Kyle.
Yeah.
Okay. Sarah.
Here.
Okay. Turner. Don't know where Turner is. Lucas.
Yeah.
Mary's here. Daniel.
Yeah.
Okay. Pim.
Yeah.
Okay. Alyssa. She's still sick. No, Alyssa. Christina. Gabriel.
Yeah.
Okay. Tylen. Tylen. No.
Yeah.
Oh, okay. Let's see. Don's here. Ksenia. Emmanuel.
No.
Okay. Austin's here. Anaclete. Here. Courtney's here. Gordon.
Yeah.
Okay. All right. First final exam you'll see on the board here is due Wednesday at 8 p.m. It's open book, open note, so you can rely on any note, all the copious notes you've taken throughout the semester, and you can look at the book. You can't take the exam with your classmates, and you can't rely on any outside sources. No Google, no Wikipedia. Probably give you the wrong answer anyway. But you can study together. You can't take the exam together. So I would encourage you all to study together. That can be helpful. But just make sure that you get started by 5:30 Wednesday because it's due by 8 p.m. and it's 2.5 hours. So if my math is right, 5:30 Wednesday, you'll want to be started on it. I thought that our last class was going to be next week, but I can't read a calendar. This is our last class. Please save your tears. Discussion post, you will have to do discussion post for week 8. It's on DNA and all that kind of stuff. Do that by Friday at 6 p.m. That will you get extra participation points for it. You've all done a great job when we were doing the discussion posts. So if you do that by Friday at 6 p.m., that's extra discussion points for you. If you don't do it, that's 0 discussion points for you, which will hurt your grade. So I would encourage you to do it. But other than the final exam, this class today and the discussion post on Friday, that'll be it for the semester. So does anybody, and the final exam is 50 multiple choice questions. It's all based on the book, all the concepts we've covered in the book. It'll be a combination. Some of them will be true, false. Some of them will be basically like standardized tests, multiple questions. Again, 2.5 hours, 50 questions. That breaks down to like 10 questions every half hour, I think. So it's doable, but it's not easy, but it's not the hardest exam in the world. So if you've done the readings and you've paid attention, you should be fine, but do refresh yourself on all the major themes covered in each chapter, and I'm sure you'll do fine. Does anybody have any questions about the final exam? And don't forget, discussion posts by Friday. So speaking of discussion posts, the McDonald's hot coffee case. Before taking this class, had any of you all heard about the McDonald's hot coffee case? Pretty much everybody, just about. So, and probably, what did you all heard about that case before taking this class? What was your understanding of what the McDonald's hot coffee case was? Yeah, that's kind of the is it Toby Keith, one of the country guys? Spill a hot coffee, make $1 million. Oh, if only it was that easy. spill hot coffee, get third-degree burns all over your groin, and spend 6 weeks in intensive care and get a bunch of skin grafts and incur tens of thousands of dollars in medical bills. Then you can get a jury award for 2.9 million, and it can get reduced to 600,000 by the judge, and you only walk away with $500,000, and the lawyers take a third of that, plus all their expenses. So really, she probably pocketed maybe a couple $100,000 in exchange for horrific third-degree burns to her groin area. So that case is an important kind of lesson in misperception about the law, misperception about particularly jury awards and how the legal system works and how facts can easily get distorted. So you all saw the videos from the discussion posts, right? And there was that Adam ruins everything. He's kind of annoying. Actually, he's really annoying, but he was right in the video. I mean, what he said was right. It's just he delivers it in such an obnoxious way that it makes you want to turn it off. You're like, I don't care what this guy has to say, because he's that annoying. But he was right. I have to give it to him. He was right. So this woman was actually, the news, and you saw the news clips where it'd say the woman's driving down the street and spills coffee all over herself. And of course, coffee's hot, except McDonald's coffee was too hot. And they didn't talk about this in the videos, but I've had another lawyer told me, and this may or may not be true, but I think it is, that McDonald's, not only did they keep their coffee really, really hot based on, customer satisfaction surveys or whatever it was they cited in the videos, but they also, senior citizens could get free coffee from McDonald's, and they would just go lounge around in the inside, take up seats and just drink hot coffee, free coffee, and sit there and talk about World War I with each other or whatever. And so McDonald's started just cranking the heat up on that coffee. This is according to this lawyer, and this may not be true, but he said they were cranking it beyond even that 180 degrees. But 180 degrees is really, really hot. 212 is boiling, and that's like a violent, bubbling away boiling. 180 degrees is pretty close, and it's real damn hot. And it ended up being hot enough that this woman was severely burned as a result. And also, she tried to get him to just pay her medical bills. I've had a lot of clients. I'm representing a guy right now that really horribly fractured his ankle. And he went to the people that own the property and said, hey, if you just pay my medical bills, I can't pay this. You all have insurance. Can you please pay for it? And they said, no. And now we're suing him, and we're going to get a lot more than his medical bills. So it is an important lesson in your first loss is your best loss as a business owner. If someone comes to you has been legitimately injured because of a product you sell or because of a defect on your premises, it's worthwhile to listen to them sometimes, or most of the time. But anyway, tort reform is, in the McDonald's hot coffee case, again, as I said, she had third-degree burns all over her groin, required extensive skin grafts, as you all saw in the video. It's pretty gross, pretty gnarly stuff. And the juries award $200,000 compensatory damages, which means those are damages that are compensating you for actual economic losses that are reasonably ascertainable, but also 2.7 million in punitive damages, which was apparently 2 days worth of coffee sales for McDonald's. So really, not in the grand scheme of McDonald's, not that big a deal, right? Not that much money for McDonald's. A lot of money for you and me, I assume for you all, definitely for me. But in the grand scheme of things for McDonald's, not that much money, but it was something that the corporations were able to latch on to and say, we've got runaway juries. They're just handing out money like hotcakes to, people that they spilled a little coffee on themselves, who knew coffee was hot. But that's not actually what was happening here. People aren't actually looking at the facts of these cases. And we saw an article about the pros and cons of tort reform. What were some of the pros that they mentioned of tort reform? Anybody?
Reducing court costs.
Yeah, reducing court costs, reducing the number of cases. They said we won't be clogged down with frivolous lawsuits. What else? Yeah, you're not wasting the regular people's time with lawsuits that are frivolous, and also limiting damages. You know, they say if we reform torts, then businesses can know that their damages won't exceed a certain amount. We'll talk about whether that's really a good idea or does that really make sense. And also eco-friendly, less paper will be used, which is, they're still going to produce the paper. It's just not going to get used. You know, it's like, it's not going to shut down the paper factories, you know, but law firms will still print plenty of paper. And you don't worry. I work at a law firm and we print a lot of paper, even for the cases that don't go to trial, which is most of them. What were some of the cons, the negatives to tort reform that this article mentioned? Yeah, reduces accountability for people. They say, I'm not going to get sued. Who cares? They also said adds insult to injury. Well, if it's a frivolous lawsuit, what that, you know, does it really? They also say it can result in more cases of negligence, which kind of ties into the reduced accountability, as people will just drive around drunk and not care, I guess, you know, or really more cases of negligence. I think they really mean in terms of businesses. You know, the businesses won't make sure that, you know, they're salting the ice on their sidewalks when there's a snowstorm, or they won't repair cracks in their driveway or in their parking lots and things like that, or will make or sell boiling liquid hot magma coffee. Tennessee passed. Now, this, of course, this case was in 92 or 94, something like that, in the 90s. Tennessee passed tort reform in 2011. It was called the Tennessee Civil Justice Act of 2011, which is kind of a funny name to say you can't get money for your injuries. We're going to call it the Justice Act. But that one, basically, the main thing it did was it put a cap on punitive damages. And that's, again, punitive damages are designed to punish a business or a defendant, a person or business that has committed some sort of wrong that is sufficiently wrong that, you know, society should punish them for it. In Tennessee, to get punitive damages, you have to prove that the defendant's conduct was either malicious, intentional, fraudulent, or reckless. And with the Civil Justice Act of 2011, it capped punitive damages at $750,000 for most cases, and $1 million. You can get $1 million if both your hands get cut off, or a hand and a foot gets cut off, or you have third-degree burns to 60% of your body. So you'd have to like pour the whole carafe over yourself. And then they'd be like, you poured it on yourself, you wouldn't get anything. But let's say a McDonald employee poured it on you. You could only get $1 million, even though you're just covered head to foot in burns. There's a lot of questions as to the constitutionality of that. I think it's unconstitutional. I think the Supreme Court, Tennessee Supreme Court's ruled on it, but I can't recall how they ruled on it. I don't know, because I haven't had a case that's worth that much money. So it's like, until I do, then I'll find out. But I'll research that then. But, you know, I think it's a unconstitutional intrusion on the American people's right to a trial by jury. A jury should be able to decide what conduct is sufficiently, if a conduct is sufficiently egregious to, you know, merit an award of punitive damages, then the jury should be able to decide how much to punish them. Because juries, you know, people make fun of juries, and they say if you're not dumb enough to get out of jury duty, then, you know, that's the idea, is that only dumb people are on juries. Juries almost always get it right. And there's a reason why appellate courts will almost never overturn a jury award of any kind, except when it comes to numbers on a punitive damages award. And I will say I had to research the legislative history of the Tennessee Civil Justice Act several years ago to law firm. And this one guy got up there and he said, you know, we're saying we need to pass this act to be a more business-friendly state, but I'm seeing articles that say Tennessee's like the 3rd or 4th most business-friendly state in the nation. Another guy gets up and says, yeah, well, you know, I've seen some that say we're 25th or 26th. These numbers say all kinds of things. We got to pass this bill. And apparently he was more persuasive. But the concept behind it, that we need to be more business-friendly, so we have to have a cap on punitive damages. What kind of message is that sending? Is it sending the message of you can pour all the chemicals you want in our waters, you know, just pollute the hell out of the place, cause all kinds of damage, and it'll only cost you $1 million? You know, you can just factor that into your bottom line. It's like, I really don't think that's a convincing, it's not a good argument to make for businesses. They're like, hey, you won't get hit with a huge jury award if you do something just atrociously awful. I think it's kind of weird. I don't know. You all disagree? I don't mean to put that into a way like a challenge. You are free to disagree.
No, I think that one of the videos talked about, he said Indiana had $1.2 million cap or something.
Yeah.
in one of the videos.
And
Basically fascinating. If we get caught, what are we gonna be liable this?
Yeah.
We put money to payment years.
And yeah, and that's, hey, or yeah, it ends up, it's like sort of like fines for environmental, pollution you cause or something like that. And it's like, well, if we get fined $200,000, but we save 500,000 by dumping this toxic waste into this stream full of endangered fish, that's a win-win there, yeah, that's cost benefit analysis. Hey, free market ethics, right? That's what that is. So that was kind of the purpose of the discussion post there, was to really introduce the torts, the concept of torts. I've talked about it a little bit in prior classes, mainly because I do a lot of torts in my practice. But this is where the first time we really gotten to address it directly, and the concept of tort reform, which we call it tort reform, and this idea that they're just runaway juries, just awarding just huge amounts of money to everybody. That's true in maybe in California. Monsanto certainly got hit with a massive jury award in the Roundup case. Because people are cancer, Roundup causes cancer, and it's probably does. So
Most states have.
no, it's probably about half. It's the conservative states have them. And then it was the McDonald's hot coffee case and kind of the misinformation from that case, and how people, and it was the news, and drove a lot of it. In the one video, the lawyers are talking about, the stories went from 900 words to 600 words to not 200 words to 50 words. And it'd be like, woman driving hot coffee, sued and got $1 million. And that's not really what happened. She wasn't even driving. But so that's kind of torts, a broad view of the tort system and of damage awards in this country. And again, of tort reform, which is something that you've probably noticed, I'm fairly conservative in my politics, but tort reform is one area that I'm absolutely not. I think it's absurd. They should let the jury decide what's right. And if it's ridiculous, the judge is always there to say, okay, you've gone a little too far here, folks. I'm going to cut that back a little bit.
We're going to talk about that again as the class goes on, as it gets to the tort section.
Yeah, sure. I mean, you got something to say on it?
Well, I mean, there's a balance, right?
Yeah, certainly.
Frivolous is one thing. Negligent is something different.
Yep.
If you're
It
flat
is.
out negligent, then you shouldn't be hiding behind a 1.2 million cap or a $700,000 cap or anything like that. I mean, take it to them, put them out of business, whatever's right for those who were served an injustice at the negligence of that other company, then so be it.
Yeah. And again, punitive damages don't even factor in a straight up negligence case. It varies from state to state what you have to prove, but in Tennessee, malicious, intentional, fraudulent, or reckless. That's not negligent, not even grossly negligent. It's got to be at least reckless, which is, that's, you're going 80 miles an hour through a neighborhood, texting your girlfriend. That's reckless, right? But if you're going 10 miles over the speed limit and you look down and you hit somebody, you're probably just negligent. But I agree, there does have to be a balance. But we talk about frivolous claims, frivolous lawsuits. This system has existed for a long time. People don't get $2 million jury awards on frivolous lawsuits. Juries don't sit there for 7 days of testimony and say, you know what, his case is crap, but let's give him $2 million. That's not how it works. It's never worked like that. And it's, again, that's a misinformation campaign, you could say. The Adam ruins everything. Again, I find him just really obnoxious, but he is right. And it is a lot of companies, corporations were paying for these campaigns for people to come out and say, the justice system's out of control. We got runaway juries, and it's driving businesses, it's driving people out of business. Like who would $1 million jury award against McDonald's? It's a drop in the bucket for them. They're making plenty of money, and if they're engaging in conduct that's sufficiently wrong, people should be able, a jury should be able to punish them for it. But, there are legitimate arguments in favor of jury reform, tort reform, not jury reform. But, I think the balance of the argument, in my view, is let the jury decide. You've got the judge there to kind of balance it out if they do kind of get out of control. But yeah, we'll talk about it a little bit more as we get into the chapter here. Chapter 9, about products liability, which is actually a specific subset of torts of negligence. And it's actually a pretty, in the concept, in the realm of torts, it's relatively complex compared to like a car wreck case. And they start you out with Wyeth versus Levine, which is the most complex, not this case itself necessarily, but the concepts talked about in that case is one of the most complex areas of products liability law, which is medical products liability litigation, which can be they're tough. They can be very tough cases to prove, but it introduces some interesting concepts. What happened in the Wyeth versus Levine case? Anybody remember?
Levine was having migraine headaches, went into that, I guess, ER, and the doctors administered, again, she had an IV push instead of an IV drip.
Yeah.
So and it's not incidentally, she was a musician, I believe.
Mhm.
So she got gangrene, lost her hand and her arm, and just impacted her career. And yeah, so labeling and responsibility for labeling is that issue.
Yeah, that's exactly right. And this case ultimately, so Vermont, she got actually a $7.4 million jury award. When someone loses an arm, the media can't twist the facts on that one. The lady lost an arm, so they're going to let that one slide, and also more complex than hot coffee. It's harder to explain. But yeah, and the Vermont courts, they upheld it all the way through, and it goes to the Supreme Court. How did the Supreme Court rule? Did they uphold the jury ruling or the Vermont trial court ruling, or did they reverse it? Yeah. And that was, which justice was that? What is it, Kennedy? Who did it say? Was it Stevens? Yeah. And basically what the court says there, and again, this is pretty complex stuff when it comes to products liability, but basically, the main point here that the majority opinion was making, or the majority was making in affirming the lower court's decisions, was that once the drug manufacturer had knowledge that if we do the IV push method, that can result in serious damage, and you need to do the IV drip method, they had a duty that triggered a duty on their part. They had superior knowledge to transmit that warning down to the physician. And of course, we've got the learned intermediary doctrine sort of dovetails into this a little bit. And that's, again, why this can be so complex. But that needed to at least be on the warning label of the drug, so that the physician could look at it and say, oh, I better not push this stuff in. I better just let it drip. Now, Wyeth, the lab that made this stuff, they were arguing that, well, listen, the FDA approved our label in like 1955 or something. And this is literally many decades later. But they said, listen, the FDA's approved it, and the FDA supersedes the supremacy clause of the Constitution, says that if there's any conflict between federal and state law, federal law is always going to rule supreme. And therefore, FDA rules, overrule state laws with respect to warning labels. But no, the majority says here that, it's an additional layer of consumer protection. State law is an additional layer of consumer protection. The FDA can't do it all. They can't oversee every single drug that's out there. They have responsibility for it, but we can't just say it's the FDA period. And if they don't get to it, well, too bad, you don't get to recover if something slips through the cracks and the bureaucrats and the FDA don't see that there's a problem with it.
So it was in 98. that they approved the label and said it must be identical to how it was submitted.
Yeah. Yeah.
So that was 2 years before,
And was this case in,
2000.
it was 2000, this one? Okay. Yeah, I didn't write down the
Yeah.
years on it.
I thought that was weird, that FDA says the labeling has to be identical to this. You put your product out with that identical labeling that's been approved. And then,
And they turn around and say, nope, you got a duty to warn. And that's, that's yet another reason why this is such a complex area of law. And I'm kind of surprised the book just sort of threw it out there to like, here's your introduction to products liability, this incredibly complex Supreme Court medical products liability case. But I think, you all think the Supreme Court, the majority was right here? Do you think that state law should add that additional layer of protection to consumers? Or do you think the FDA, hey, if they said that's what the label's got to be, that's what it's got to be, and we were trying to comply with that law? So what if this lady lost her arm?
if the FDA says that your labels must match this, they talked about they changed in 2007, they put out additional stuff saying you have to update it as you go
Yeah, and that's
after the fact.
yeah, and that's, so how do you know, how can these manufacturers, to be fair, yeah, how can they know when the law says it's got to match this, it's got to be identical, period? And they say, but no, they're going to turn around and you got popped for $7.4 million. You didn't put in a different label on there. Is that really fair to them? It's one of the areas where if the law isn't clear and you don't have clear guidance, and you just you say, well, FDA says to do this, that's what we'll do. And then you turn around and a jury hits you for $7.4 million because the lady lost her arm.
Thank God we don't rely on the FDA to make the safety decisions.
Yeah,
You, the jury, make the safety decisions.
yeah. And that was,
Legal gets a little feisty, doesn't it?
yeah, that's, even you're a plaintiff's lawyer, you have to do that. You got to put on a show for your client to justify all that money you're going to take from them. But there is definitely, you got to puff your chest out, ruffle some feathers. It's all part of the act. But in Alito, he dissents all the time. Alito, how many dissents do we read from this guy? You all got 2 in 3 cases. And of course, he says, well, what was Alito arguing in his dissent? Why did he think that the court got it wrong? Yeah. Yeah. Well, you already the majority made the point, or one of the rationale for their holding was that, the supremacy clause is only going to kick in. Congress can only expressly override state law, or can only override state law when they expressly do so. And there's a clearly stated intent. This is going to rule over state law. And the position the majority took was it's got to be just absolutely crystal. It's got to be spelled out right there in the statute. Alito, he says that looks, and Congress's purpose in authorizing the FDA to determine when and under what circumstances a drug is safe makes it clear that it intended federal law to take precedent over state law with respect to this issue. And that was, he said, you don't have to just spell it out explicitly. If they make a law that says FDA determines when and under what circumstances drugs are safe, then that's clearly going to override any state laws that are to the contrary. But again, this is a majorly complex issue. And he basically said, he did make the point that, like you did, Don, that the majority is allowing a state jury to second guess the FDA's labeling decisions. To say, 12 people that couldn't figure out how to get out of jury duty get to decide, no, that should have said you can't do the IB push method. So, it's a tough issue. It is what it is there, but was the court right? Probably. It's better to err on the side of protecting consumers from dangerous drugs. And you've got to look at the reality, even though the law is written in a way that at the time they said, listen, we were doing everything we could to comply. And that's how a case like this gets to the Supreme Court. If they knew they were screwing it up, they'd be like, oh, let's fold, let's settle. It's not entirely clear here. And that's why the Supreme Court ends up looking at this case and having to rule on it, is because that issue it was still up in the air at the time. But again, the majority, the law is generally going to want to favor the consumer and protection of the consumer, protection of the public over, just a technical compliance with the law just on its face.
There's no way the FDA can monitor all of
Yeah.
technical terms and requirements, but as matters of law, it is the FDA's responsibility to do that.
It is, so it is. But the reality, as you're pointing out, is the FDA's, it'd have to be, a tenth of the population would have to work for the FDA to be able to go through everything and verify every single one of these drugs is complying with every single requirement they've got out there. And a lot of times FDA requirements, they can't keep pace with the technology. It's this new technology is going to come out. They test it. They have a rigorous testing regime. It is actually, they do have a very comprehensive and very in-depth approval process, for medical devices and for drugs. So it's not like you just go out there and they're like, sure, see what happens. And then something happens. They're like, oh, you need to put a label on that. There's a process a very detailed process they have to go through. But they're still not going to get it. They're not going to get it right every time. And they're going to miss things sometimes. And again, technology, as it develops, sometimes they'll get pre-market approval. I'm involved in this lawsuit involving hip replacements, which are overall pretty good thing. You got a ball in a socket and you can pull those out, put in artificial ones, and people it's like they're 20 again, people whose hips were so bad they could hardly walk. Well, this one company, which shall remain nameless till we settle the suit, there'll be an NDA. I won't be able to tell you, but they did a metal on metal. The ball that goes into the leg, they pull your leg up over your head and slice it open and carve out the top of your femur bone. It's disgusting. I don't know if that's the right bone, but they stick that, they drill in, they put in this ball that makes a new ball, then they carve out your hip bone in your pelvis here. And they put a new socket in. This was metal on metal, and it's made out of primarily chromium and cobalt, which is these two metals. And it was, this is going to be great. This is great. They got pre-market approval for it. FDA's like, sounds good. Get it out there. Well, what happens is over the years, metal grinding on metal results in little bitty shavings of metal entering people's bloodstream and pooling up in their feet. These people go get their blood levels tested. And you're like, hey, something's wrong with me. They test them and it's like, oh, you have extremely elevated concentrations of chromium and cobalt in your bloodstream. So turns out, and now there's 880 or some odd lawsuits have been filed against this company as part of this massive multi-district litigation over whether this product was, was defective. And it involves a lot of these issues with the medical products liability. And that's why I was surprised the book did this. I'm like, man, it took me a long time to figure out just how to put together a complaint to sue these people. And the book's just like throws it out there. But, the FDA is not going to always get it right. They didn't get it right in that case. It turns out ceramic, if you ever have to get a hip replacement, do not do metal on metal, do ceramic on metal, because that won't result in metal shaving off into your bloodstream. And who knows what effect that's going to have, because we don't have any examples in history of what happens when you got a bunch of chromium and cobalt in your bloodstream. We do know what happens if you got a bunch of lead or a bunch of mercury, and none of it's good, right? Iron, on the other hand, is okay. But so what advice would you, any of you, give to a pharmaceutical company deciding how to label a new drug? We better put everything that's possibly could go wrong on there. Make that thing like 10 pages long. One of the ones we have to open a little booklet and it folds out like on the back of a pill bottle. You thank the lawyers for that. I would start with do whatever the FDA says and then add some more stuff onto it.
You would think you'd like to say whatever your product is approved for.
Yeah, but
Explicitly told to put this on the label. Exactly.
Yeah, but then remember, I don't know, the last class or the one before that the guy, First Amendment says you can go promote off-label uses of prescription drugs. So it's this weird, you better warn of everything. But if somebody goes and says, use it for something else, they're like, it's totally fine. So this is an area of the law that they're cleaning it up. It's getting a little bit better, but it's a little bit like the Wild West in terms of, what would you do? Yeah, whatever the FDA says, but then add some stuff on top of that. R&D is important, right? You just make sure, just test it on those lab mice, just left and right. If they start growing, extra ears, throw it on the label, whatever. Just every possible thing that could go wrong needs to be on that label. That's called CYB, right? And do that in everything, but especially if you're making a new drug. The book talks a little bit about, there's a case, Wyeth versus Weeks, and I'm sure you all did the extra research that the book asked you to do. Alabama Federal District Court was looking at the issue of whether a brand name drug manufacturer can be held liable for failure to warn or for misrepresentations on their labels for damages caused by a generic drug manufacturer. You all know how the court ruled in that case? Yeah. They said that brand name drug could definitely be held liable. Essentially what that court, now Alabama is, we talk about runaway juries. Alabama actually is a state that is notoriously, you can get huge jury awards in Alabama, because apparently you can sue in whatever county you want to, and there are like 3 counties, not state level, of course, there are like 3 counties where everybody's in on the game. Juries are in on it, lawyers are in on it, judges in on it. There's this one lawyer who has an airplane that the Alabama basketball team can play basketball in the airplane. What kind of airplane is this? But yeah, that's Alabama's not like Tennessee. Tennessee's actually very reasonable when it comes to our laws and our court systems. Very reasonable. People are surprised to hear that, but one of my friends is up in Michigan working as a general counsel for a multi-state law firm. He's having to research all these other, bless you, all these other states' laws. And he's just like, these laws are all so stupid. And like, Tennessee is actually very reasonable. These are well-written laws. And I was like, who would have thought it? I definitely didn't. But anyway, Wyeth versus Weeks, they basically said that the manufacturing process is irrelevant to misrepresentation theories. So again, they're not saying it was something in the drug itself, like you added, arsenic to the drug and I was poisoned. They're basically saying if it's misrepresentation or failure to warn on the label, they say manufacturing process is irrelevant. So whether, aspirin makes, maybe whether it's Bayer or whether it's CVS, doesn't matter. The label was created by the brand name, and the generic people just basically repeated it. They just copy paste.
When they place all the liability on the drug company, advertising, generic, why would you not? I understand, I guess there's a period that they have exclusive rights to.
Yeah,
the drug, but-
yeah, which we'll talk
So
about
if you're
in
a
chapter
generic
10.
company, all you do is make drugs that somebody else did all the research and development on.
Yep.
And you have no liability unless you screw up manufacturing.
Yeah, well, you have no liability for misrepresentation or failure to warn on the label. Now you could, if you, as a generic brand, manufacturer, didn't transmit the warning from the original. So if, let's say, the parent drug company, that the original drug manufacturer, they had the laundry list of just all the things that could go wrong. This heart attack medication may cause heart attacks. I love those. It's like depression, antidepressant may cause risk of suicide. And you're like, then why would I take it? But if they, the drug manufacturer does everything right. Generic guys, they come in and they make it. They don't screw up the manufacturing process, but they don't transmit all those warning labels. And this Wyeth versus Weeks says probably still wouldn't matter. I think you'd have a better case, though, to say, listen, if you didn't just copy it directly and you left some of it out, then it could be on the generic manufacturer for failure to, they have failed to warn by failing to copy that. But yeah, it is. It does. Drug companies, they have a lot of risks, but these drugs, when they first come out, can be horrifically expensive, like absurdly expensive. And so these drug companies are making they're factoring that into their costs, you know,
Yeah,
and
I
that's
mean,
so,
they're definitely doing well.
yeah, they're doing fine. But, and they'll factor that into their process, you know, we have to charge enough money to cover our butts in case, you know, the generic guys 20 years from now just totally screw the pooch. You know, we need to make sure that we're covered because we could be on the hook for it. And that's part of the system. Is it fair? Yes and no. Sometimes it makes sense. Sometimes it doesn't. You know, clearly you don't think this Wyeth versus Weeks.
Yeah, I was surprised by it.
Yeah, it is. It's kind of surprising. You know, I honestly, I didn't think when I was looking at it, I was like, there's no way.
And not being sued or having any issues with it for a decade or however long my exclusive
Yeah.
rights were. And
Then they
then
come
5
in.
years into you selling it, became a problem.
You mean Turner,
Yeah.
not me.
So, Turner doesn't do good.
But no, I mean, yeah, it is kind of, and it tells you if you're going to be a brand name drug manufacturer, you better keep an eye on all the generic guys that are going to try to make your drugs, you know, make sure they're not going to screw things up and get you on the hook for some big jury award. So the book now talks about independent administrative agencies. You know, we talked about OSHA before, which is a little executive agency under the Department of Labor, which means that the president gets to say, you're hired, you're fired, etc. They can just pick and choose. Well, with these independent administrative agencies, and that's the FDA, which is the Food and Drug Administration, the Consumer Protection Safety Council, National Highway Traffic Safety Association or Administration, whichever it is. These are commissions where you have commissioners established by Congress. Their term limits are set by Congress. Yeah.
TVA is like that.
TVA, I think is, yeah, TVA, I'm pretty sure is. Who those guys are making. That's good money. All you need is a friend in politics in DC and you can have it made. Those guys at TVA, I mean, they don't even know what they're doing. They're making like millions of dollars a year. But anyway, so the book does get one thing right. They say regulation is spotty at best. Of course, they say that from the standpoint of we need more because it's so spotty. But for some of us, it's like, well, maybe it just tells you that it doesn't work. But anyway, Food and Drug Administration, obviously food and drug. And since 2009, they've been controlling tobacco, which the book would never fail to omit that information. And they said under Obama, the FDA came alive.
More stuff than they were funding.
Yeah, and they came alive. And it's like, okay, calm down. But you know, big one, the FDA the book's talking about it. The FDA has really started controlling dietary supplements, which was a big thing. I actually worked in Atlanta after college. It was like some of those crap things. I'd just packing up vitamins and selling to people. I mean, people were buying them left and right. They were selling like hotcakes. And I'm sure that was just sawdust in a capsule. That was like nothing. I guarantee you these people, if they lost weight, it was by accident. But that was something the FDA really started clamping down on because people were putting like, what's that? Kratom, I don't know, something that's like in Middle Eastern, they use it a lot in the Middle East. It's like this related to coffee and basically gives you like a caffeine high, but the FDA like freaked out about it. It's like, it's just a plant, man. But anyway, and opioid abuse, which has been a real problem. How much has that regulation really helped? Well, Tennessee, the state is suing Food City right now for running a pill mill out of Food City, the one on Bearden. It's where I buy my groceries. I'm like, I could have gotten pills from here just for whatever, and they were just pumping them out. But it's a little bit confusing with the FDA because the USDA, you know, United States Department of Agriculture, there's like an overlap when it comes to food regulation. USDA does meat and poultry, but the FDA does fish and some meat and all the vegetables and all that. And then the book kind of flips it around on you a couple times and says USDA does vegetables. And it's like, which is it, man? Keep it straight. But I think the major issue that we're seeing now is with these government regulatory bodies is a lot of our food is imported. Like a huge amount of our food is imported. When they say like 60 to 75% of our food supply is all imported, while we sit here and grow corn and soybeans to sell overseas. Doesn't make a lot of sense, but if people are making money, I guess it is what it is. But you only have issues with tainted peanut butter. A bunch of people get sick from bad peanut butter and bad meat. And that's when the FDA will go in and say, you got to recall all your meat. And it's good. The system's there. It encourages these suppliers, or I guess growers and things like that, and wholesalers to be proactive, because they don't want to get the FDA breathing down their necks on something. So they'll do voluntary recalls. But that's kind of, that is what it is. There's not a whole lot to discuss there in terms of the FDA and in terms of these independent administrative agencies. But they're, in all, that's something that you all think is a good thing. We should have government agencies checking out the food, making sure people aren't selling us tainted beef, chicken wings with coronavirus on them.
So is it predominantly import foods? I deal with.
No, it's all food, right? So, but when it comes to imported food, how much can they really do? It's the same thing with the drugs, but actually on a much larger scale. I think the book said they can only actually inspect something like 1% of what gets imported into this country. Just realistically, you got a container ship that comes in and it's just, hey, I got 42 million chickens. We got to get them off this. Well, wait, we got to inspect these chickens. And they're like, well, they're thawing out. We got to get them out of here. I'm like, okay. And they inspect a few of them. And then Chinese are like, whew, and they put all the bad chicken in. They're like, man, we dodged a bullet on that one. Get those bad chickens in the market. But I'm kidding, sort of. I'm not kidding. So, it is, again, it's the same problem with the drugs. There's only so much they can really do, but it's better to have those safeguards there than to not have them, right? Because, and there is that, again, that it gives that motivation to suppliers to kind of watch what they're doing. Because if they know that we could get hit with a big fine from this federal agency, they're going to be a little bit more careful in what they do. I can't remember what part in the book where they said that, like, well, I guess it's a little bit later when they're talking about, caveat emptor and all that since 1266, you can't sell adulterated wine and victuals. But so that's been around for a long time, that you can't, if you sell bad meat, bad food, bad drink, you can get in trouble for it. People can sue you over it. And that certainly does happen, especially now with even small farms. It's not just the big companies. Small farms, people are only that farm to table. We have farm fresh eggs, but then sometimes they forget to clean the chicken poop off the egg, and they do a lightly poached egg or something, a raw egg on it, and it's got salmonella all in it because you didn't clean the poop off the egg. Then that restaurant gets sued for a bunch of money. That happens. I know it happened last year in Nashville. I helped some people do it, but it's in the book. Emily Montgomery, this article talking about GMOs. And this is a interesting topic because there's a huge divide between the US and the EU with respect to genetically modified food. In the US, it's, like 94% of soybeans, 89% of corn, something like, 96% of cotton are all genetically modified. And they'll modify, it's mostly, Monsanto will go in there to make it so they're more resistant to Roundup and glyphosates. I call it Roundup Ready. They're ready to spray chemicals all over it. But, and we've got in the US, I think we've got something like more than 190, as of 2016, so it's probably more now, more than 190 different varieties of genetically modified crops have been approved in the US. And in the EU, by contrast, it's extremely difficult. It's like highly regulated. It's very difficult to sell genetically modified, or to get approval to sell genetically modified food. And if your food product, whatever it is, if it has more than 0.9% genetically modified food of any kind in it, bless you, it's you have to label it. You have to say this is bless you. I have to say it. It's like then you got to put a label on it to say this is all genetically modified. And it's created a lot of friction between the US and the EU and their markets. It's basically kept US farmers from being able to sell a lot of their products to the EU. But I mean, when all you're growing is corn and soybeans, and Europeans aren't into that stuff. But it's also created problems for organic farmers and people who want to market their food as GMO free. Because what you have is cross pollination. If you plant your field of soybeans next to the, well, if you got soybeans, they're going to be genetically modified. You plant your field of corn, you've got some, heirloom corn from your family's been growing for generations since the Revolutionary War, and some guy plants his Monsanto corn next to you, and next year all your corn's all screwed up. It's all cross-pollinated with Monsanto stuff, and then your crops really, you can't be like, I've got my special GMO-free heirloom corn that you can sell for $4 an ear. Now you've got this cross-pollinated stuff that you can sell for 10 cents an ear to be made into biodiesel. That takes more diesel to produce than you actually get. So it takes like 1.3 gallons of diesel to produce 1 gallon of ethanol. Makes a lot of sense. And then the ethanol screws up your engine, and your engine can't tolerate it. It's just, but it helps the corn farmers. And that's really what we're doing here. It's a welfare program for the corn farmers. And of course, organic farmers can lose organic certification when they get this cross-pollination of GMO crops, in their fields. And obviously it's not going to happen as much in Europe because they're not letting them have the GMO crops all over the place. Now there are other concerns. People have said, well, if you're because basically what they'll do with these genetic, my understanding, pretty basic, but they'll take favorable genes from not even from the same family of plants, from like a totally different plant to make it, and they'll just plug that gene in. Now we've done genetic modification on a kind of a longer term basis, has been happening for centuries, millennia. People have been grafting different fruit trees together to create new varieties. People have been doing that for literally hundreds of years. But here they're going to like the molecular level, they're taking actual genes and plugging them in. And they're saying here is, the book points out, you could say they're growing corn, they take something from a peanut plant because it's got better resistance to some particular type of pest or something like that, and they plug it into the corn. And then some kid's sitting there eating corn who's allergic to peanuts, and he's like, well, it's corn, it didn't have peanuts in it. And all of a sudden he goes into anaphylactic shock because it's got peanut genes in it, right? Now, I don't know, does that really happen? I don't know the details or the science behind it, but that's one of the concerns that people have with these GMOs is, it could trigger allergic reactions in people that aren't going to expect them. Different genes from different things that they are allergic to have been put into plants and they didn't know, plants that they're traditionally not allergic to. And the long-term effects are unknown because it's a relatively recent phenomenon. It's the same thing with the hip thing I was telling you about, chromium and cobalt in the bloodstream. What's that going to do long-term for all these thousands of people that have it? We don't know. Probably not good, but who knows? Time will tell. Other things, it's creating super weeds. So you've got weeds that will get the genetically modified, organ, somehow it'll cross-pollinate or it'll get those genetically modified bits in them and create these just monster weeds that can just grow like gangbusters everywhere. You'll get super bugs. The insects become more resistant, which kind of defeats the whole purpose. The genetic modifications will make it more resistant to the bugs. Well, what happens is the bugs get resistant to the genetic modification and they become even more powerful. And pretty soon it'll be like that Starship Troopers or whatever, right? Did you all see that movie? That's an old one. Yeah, but super bugs. Then you get reduced biodiversity and the effects on other, organisms, non-target organisms. So, and really biodiversity that's a big one because they're not, even for like corn, there are like 100 varieties of corn. How many of them are genetically modified? Probably like 4 or 5. So you're only going to have so many varieties, which means that if some superbug comes along and wipes out a particular variety, instead of having 99 other varieties to fall back on, you got 4. It's what happened to the banana. The current banana, whatever it is, Cavendish or whichever one we eat, it's getting wiped out. I mean, we're pretty soon we may not have bananas. But that banana was the replacement that didn't taste as good for the banana that got wiped out in the 50s or 60s. Some bug came through and killed all of it off. So that's the artificial banana flavor, that doesn't taste at all like a regular banana. because when they made that, it was based on the old banana that had a much like more intense banana flavor, but then it gets wiped out by some disease, pest, whatever it was. They bring in this new banana, and that's the dangers of a kind of monoculture crop, right? I'm all into farming, right? You all are asking me about it, so we're going to talk about that. But that is, I mean, it's legitimate that, if you have one variety of something, a disease comes through and wipes it out, you're screwed, right? And you being the farmer that grows this, but also the end consumer, no more bananas. We still have bananas, but I don't know, pay attention. They'll start getting more expensive. You won't see them as much. Or maybe they'll save the banana. I don't know. Citrus crops in Florida are screwed. The greening, you can't get good Florida citrus anymore. It's sad. But those are the dangers of monoculture. And again, with like Roundup Ready, we get these Roundup Ready varieties equals more Roundup equals more glyphosate resistant weeds. And so this cycle, the problem is trying to fix, ultimately it can end up making it worse. So then this lady, Anu Bradford, talks about the Brussels effect. What is the Brussels effect that she's talking about?
They had the ruling that was unfair, the US file. It's eliminating competition, basically.
Bless you. Yeah. That's essentially that these other, so the EU takes this aggressive anti-GM, genetically modified food stance, right? They say we're not going to import it, we're not going to use it. In the EU, their focus is on kind of small farms. They're doing kind of specialty, fancy crops, right? Fancy European food, which is great. I love European food, but that essentially, you've got to label it. If it's got 0.9% or more, it's got to be labeled. And what's happening is that, agricultural exports are being limited because other countries are kind of following suit. That's the Brussels effect. So, Australia, Canada, all these other kind of countries are like, this sounds good to us. GMOs sound pretty scary. And so the US, their export market is being restricted by the Brussels effect, is kind of what she's getting at. And then the US did, they went to was it the WTO probably? Yeah, and they claim that that EU's health concerns, and this is kind of the same thing with we were talking about with Title VII pretextual reasons, where you're saying, I'm firing him because he wasn't doing his job. No, but really I fired him because he was gay, right? It's the same thing here. They say, you're saying you have health concerns with with GMOs, but what you're really doing is you're protecting your farmers from foreign competition. The EU says, no, it's genuine consumer preference. They say our people don't want to eat GMO food. I don't know. Who do you think's telling the truth here? Who knows?
Combination, I think.
Yeah, it's almost always a combination, right? I think they do. I think people do have legitimate health concerns, primarily from the unknown, not so much from, people are dropping like flies after eating Monsanto corn. But you do have your European countries. I think they do have a genuine preference for, these people have been growing this kind of food for hundreds of years and they're good at it, and it tastes better. And in a lot of places it does, not in England, but in other places it does. It tastes better. But the WTO ultimately ruled against the EU, right? And the EU is like, yeah, we'll get to it. And they haven't done it. They're just not going to do it. They're just like, yeah, we'll do it. It's been like decades. They're not going to do it. They're never going to do it. But, the book does ask us, and I think it's a fair question, should the United States, talking about you've got the FDA and the USDA, and it's all kind of this patchwork of regulatory agencies that overlap with each other. Should there be, the EU seems to have this kind of overriding guiding principle. GMOs are dangerous and we should be careful and we should regulate them and make sure that they're safe before we just, release them out into the farming world. Should the US have something like that? Should we have an overarching or overriding guiding principle with respect to genetically modified food? Yes, no,
think it kind of depends so much how you define a GMO. Selective breeding, like genetically modifying something.
Yeah.
To be like a guy in a lab coat.
Yeah, I think that's a fair, how do we define it? Yeah, because again, that's selective breeding. That's something that's been happening for a long time. Dogs are genetically modified. Yeah, technically, it took a long time to get there, but it's not like cavemen were running around with little lap dogs. That didn't happen. That took a long time of let's make this dog smaller and more annoying, and they succeeded. But in all seriousness, it is. How do you define it? What is, and here when they're saying genetically modified, yeah, I think that for most people it calls to their mind because that sounds like a guy in a lab coat is, plucking a cell out of here and sticking it over there. But you can also graft plants like tomato plants. You can take the stem of one variety of tomato and you can cut a little, like the stalk off another one. You can stick them together, and if they live, you've got a whole new variety of tomato and you can combine the best of both of them. Is that genetically, would that fall under the GMO principle? I mean, I think that's a very fair point. How do you define it?
I think what you could do is like, say like this, like, for instance, like you said, like they add a peanut to like soybean or something.
Yeah.
Like, they can be like this product may contain peanut.
Yeah. Yeah, and that's something I think, and that's really where I think that gets to the definition of what we're talking about, because crossing a couple of different varieties of corn, it's corn and it's corn, and you're making a new, or tomatoes, one tomato, another tomato, boom, you got a third tomato. With taking a peanut gene and sticking it into a soybean plant, that's a little different, because it does, I think you're right that it would kind of implicate warning requirements. Okay, if you used a peanut gene in here, you need to make sure there's a warning for it. But then how do you make sure that gets down to the farmer? He grows the soybeans and he's like, Monsanto just tells him, these are the great new soybeans. They're super resistant to the soybean bug or whatever, eats soybeans. And he's like, great. And he sells it off. And I mean, probably sells it to China. So ultimately it's not going to get back to him. But because I can tell you, if you sue Chinese companies, which I've done, I guarantee you they just laugh at it and put it through the shredder. They don't give a damn. They never respond. But it's okay. That's what do you expect? But yeah, you got to have protection. I think where you have some sort of regulatory scheme, maybe not as aggressive as the EU, but maybe a little bit, more controlled, or a little bit more oversight than we currently have in the US, because it really is. It's, farmers love it, because here I can plant, 200 acres of corn, and I get a much better crop. I get higher yields, and that's the argument in favor of the GMOs is you're getting higher yields. More people are getting fed, and they make it a big sad story about, it's helping people who are starving, but no one in the US is starving. I mean, well, some people are, but not like in other places. I don't know. But yeah, those are very legitimate concerns. And I think that's kind of how you have to look at it. There's probably, as with most things, the answer is usually somewhere in the middle, right? Now, what about this bovine growth hormone? Is, a lot of they'll treat cows with it, and they say in the book they make it sound like it's the worst thing that was ever, that they get udder infections and the cows are just dying from the growth hormone. But it talks about this kind of double labeling requirements. The FDA, you treat your cows with the bovine growth hormone, and it's like the little R and then BGH. And they say you have to label it, and they say these cows were treated with BGH, but you have to put a label on there that says the FDA has found that there's no appreciable difference between untreated cows and treated cows. Is that an effective labeling scheme?
No, I mean, it's like, hey, this is in here, but it doesn't matter.
Yeah, it makes you be like, why did you tell us? Be like, some people want to know, and it really would probably a bunch of people complain. Greenpeace or whoever the food group equivalent of Greenpeace was like, we have to know that we've got bovine growth hormone in our milk. They're like, fine, we'll put a label on there, but we're also going to make you put a label that says it doesn't matter, doesn't make any difference. But it's kind of confusing, isn't it? You're just like, I mean, I guess it does, it lets the consumer know and people can make that decision of, I don't want to drink, or I don't want my children to drink cows that have been treated with bovine growth hormone, even though the FDA says right there on the label, it doesn't amount to a hill of beans, doesn't matter, who cares? So I don't know, is that an effective labeling scheme? Would you do it differently?
Both of them on there, blah, blah.
They just cancel each other out.
Yeah, like, I mean, that offer legal protection, like, I got sick from ingesting bovine growth hormone, and there's a label that tells me that doesn't matter.
Yeah, I mean, if you're saying I got sick and it was because of the growth hormone, not because, the milk was bad or anything like that. Yeah, I mean, it would, because they'd say, listen, we told you it had the growth hormone. And if you think that's something that's going to make you sick, you didn't have to buy it. But more importantly, we got this label here that tells you, the FDA tells us, and that's where again, you've kind of got that Wyeth versus Levine problem there, where it's stately, you get some jury, if you're in Tennessee, you're probably fine if you're the dairy farmer. If you're in California or Vermont, who knows? A jury could just say, lawyer gets up there, and fortunately, the FDA doesn't control what bovine growth hormone really does. You do. And then he makes a big, puts a 20-minute YouTube video up there or something, and the jury gets all whipped up. Well, it's just, look at these cows, and they're all just, dying cows. And they're like, the cow's dying, they're taking milk from it. And they're just like, $1 million. Maybe, it depends on the state. But probably you'd be safe, with that labeling requirement. Again, I think it goes to the concept of you want to provide the consumer with as much information as possible, let the consumer make that decision, even if it actually doesn't matter, right? Which I think it's a fair point to say. It is, it just cancels itself out. Why is it even there? Well, it lets the consumer know. Consumer can make a more informed choice based on what the consumer wants. So, and that'll put us in the Consumer Product Safety Commission, which was created in 1972, regulates products, basically did nothing for the majority of its existence, just kind of was there. It's sort of like TVA, people were just collecting paychecks. That was probably a sweet job in the 70s. Oh man, just not do anything. But so the first major safety standard was 2006. What's the math on that? I mean, that's a long time. That's a real long time. That's 34 years of just doing nothing. And they're like, you got to do something. You're like, fine. And who knows? I don't even know what the safety standard was. Did it say what it was? Anyway, sweet job. Government jobs are always sweet, but that one's like that's like the cream of the government jobs. Oh, they fire say, oh, fine, your mattresses can't catch on fire. Whew. All right. I'm back to slacking off. But so it gives, that commission has the power to fine companies for failing to report defective products. And this is a problem that is becoming more, and I rip on China a lot because I like to, and Amazon. You like to buy stuff on Amazon, you can get for cheap, right? Actually, usually not as cheap as Walmart, but still pretty cheap. And people will get things like, dehumidifier, or you get your hoverboards are pretty sweet. Your kid wants a hoverboard. You're like, give me a hoverboard. And you're like, okay, this one on Amazon, that's a pretty good deal. We'll get this one. Well, this family in Nashville made that mistake about 4 years ago. And the charging cord on this thing, and I have a lot of these products, charging cord would just burst into flames, just sort of randomly burn their whole damn house down. And they were like, nice $1 million house, and which is not much in Nashville. That's like a shack in Nashville these days. But burned down their nice house. They had to climb out the second story window. Dad breaks his arm, falling off the ladder. I mean, it was just disaster because they bought this cheap piece of crap, hoverboard from Amazon that got shipped in from China. Then you go in and you look at the, product description, and it's just sort of this like bad English, just whatever, doesn't really have any information. There's no warranty. Who manufactured it? Nah, who knows? Go through, you all been through Amazon trying to return something or contact us. I mean, they make it easy to return stuff, but contacting the seller, good luck. And then you go to their website. I mean, I was helping the defense on this. It was just crazy. I mean, you go to their website, they'd scrubbed everything. I went on the Wayback Machine. They used to have a warranty that didn't say anything. Then they just took it off completely. And I don't know if those people ever recover. Probably not. But, and it's again, same thing like with the food. We have so many imported products now that you're no longer relying. It's not like the government can go, okay, we're here with the Consumer Product Safety Commission. We're going to go to your factory and we're going to look how you're making your products. And we can pick one up and we can test it and tell you need to change your manufacturing process. No, this stuff's all coming in, on a big old container ship. They can get through one container and then the day's over and they ship off the rest of it to all the different Walmarts and the Amazon warehouses and stuff. And you've got these defective products, that are catching people's houses on fire. The IKEA, I'll lay off the Chinese. Well, let's make fun of the Swedish. They're crappy IKEA dressers that were falling on kids left and right. I mean, what were these dressers made? I mean, I don't know. What were these kids doing? That's what I want to know. But they had several dressers were like falling on children and crushing them. And so finally IKEA I think they had to recall their dressers or fix their dressers. But this huge increase in imported products, just as with food and to a certain extent with medical drugs and medical products, we're still, drugs, maybe a lot of those are made offshore. Products, we're still pretty good about making them here. But it's the same thing. How the scale of it is so big, that how can the government effectively look at these products, make sure they're safe, and implement regulations that these companies have to abide by. And then you got companies that they're not going to abide by them anyway, because there's no accountability for them. There's no reason for them to do it. They can sell off enough of them and then they get in trouble. They just sort of fade into the background, open up a new factory and ship it up under a different name, right? And it happens, when you get adultery, you get products, they'll slap a Ford logo on it and Ford had nothing to do with it. It's a tough, it's a tough situation in a lot of ways. But that commission's there. They didn't do much for a long time. They still don't do that much, but they've made them start to work, and that's good, I guess. If they're going to pay them, at least make them do something for it. National Highway Traffic Safety Administration has 1970, and they've done a little bit more. They're a little bit more. They do a little bit more. And that's things like faulty tires, the Toyotas that would just accelerate, and just whether the people, there was people called into Toyota and they're like, oh my God, that car, it won't stop. And it just goes and crashes off into it. And it's like, oh, this is horrible. The Takata grenade airbags that would just like launch shrapnel into you. It's like, not only are you going to be in a car wreck, but you're also going to have a grenade go off in your face. Because grenades aren't like in the movies, it's like not a fireball explosion. It's actual just bits of metal and stuff that just go shooting out. And that's essentially what these airbags were, the Takata grenade airbag. That's what I call it. Then you see in this, and that's, you all may have had, if you had older Fords, like a 2005 or something, you probably got a recall notice, hey, you got to get your airbag fixed because it might kill you rather than save you. And that's where, but a lot of times they were just reacting, and it's the same as true for other government agencies. A lot of the times they end up having to react to what they've missed, and and I think especially with the NHTSA, there's not like this mandatory, they can't go around and just inspect every factory. They can't go around and inspect every vehicle. So it's just when they get a certain number of complaints, okay, we've had 15 people call us up and say that, their tires would just explode randomly. We probably need to call up Firestone and see what's going on, and they can make them do a recall, which same thing that the CPSC can do, and the FDA. They can force recalls. They can say you've got to pay out. You got to pay into a settlement fund to get these people reimbursed for the damages your crappy products have caused. And it's like VW, that was a big one. Volkswagen's, and that's a little different. It's not that it was unsafe or was causing like specific harm to certain people, like the cars weren't blowing up, but they were, that was the defeat device, right? It would say, oh, if you're being tested, it would just have this, like, it would run at like 4 horsepower, and just hardly put out any emissions at all. And they'd be like, wow, what a clean vehicle. And they go sell it to the hippies and they buy it, like they just buy them up. And it turns out that you're just spewing, it's like a tractor trailer levels of just absolutely just spewing emissions into the atmosphere. So they duped all their customers into buying these massively polluting vehicles. You can probably get them pretty cheap now. I'll probably buy one, but who wants to spend? Yeah, Exactly. And who wants to spend $40,000 on a car? It's ridiculous. Spend $5,000 on a like a polluting machine, and who cares, you know? But they actually, you know, VW did get in a lot of trouble for it. It wasn't just, and this is where you saw the government really start to actually flex their muscle a little bit. They put some people, the one VW executive that was in America, they threw him in jail. You know, they fined him billions of dollars. And they actually like reimbursed all their, you know, they basically, I think their customers could sell back their cars for full value, and then
Like pre-emissions value.
yeah, like at what they paid for them. Yeah. So VW took a big hit on it, and they admitted, they were like, we did that so that we could defeat government regulations. And I go, well, if I was their lawyer, I'd be like, why did you say that? It must have been in writing somewhere, and there's just no way they could avoid it. You know, do the right thing here. Like, not when it's going to cost you billions. No, I'm just kidding. Always do the right thing. This is an ethics class. And what is right is more important than saving money. Free market ethics would say, Milton Friedman's back there. He's like, no, money, man. But how about the Ford? Now, you all heard about the Ford Pinto. It's kind of old, right? But so there was this design. Ford wanted to compete with these Japanese and European cars that were like these small, sleek little cars that can get around, you know, little small, windy European roads or whatever. And we want them here in America. It's like, why? We got plenty of room. But anyway, they wanted to compete with it. So they make this design for this little hatchback. And they're like, we want it to look cool. We don't really care if it's safe, as long as it looks cool. So they put the gas tank between the axle and the bumper. And they had a bunch of like bolts sticking out, all kinds of just sharp stuff, and this crappy little bumper that would just like fold like a cheap suit if something hit it, and it would just crush these gas tanks into the back of the axle, and just these cars would just burst into flames like really easily. I mean, you just getting like a fender bender, like someone rear ends you at a red light, and next thing you know, you're just like your whole car is on fire. And what it costs, you know, the book talking about that case. And they had tests that revealed the design wouldn't work. They're like, we want a cheap car. We'll sell it for $2,000. A new car, $2,000. But boy, money doesn't go as far as it used to. But so they had these tests. They knew it was defective. They knew this was a dangerous design. And they said, hey, it looks cool. Go for it. And it turns out the fixes were really cheap. It'd have been like $10 a car at most. Like that's if you really went above and beyond to make it way safer, like way safer, where it could withstand like 50-mile-an-hour crashes without bursting into flames. And they're like, no, you know, $10 per car, you know, those numbers add up, right? It's like add $10 to the list price, make it $2,010. They're like, no, $2,000, make it dangerous. And that's what they went for. And they ended up, when I talk about runaway juries, right? The woman her son was like severely injured, and the woman just burned up alive. It may have been vice versa. She got what, $3.5 million plus $125 million in punitive damages. Did Ford deserve that kind of punitive damages award? Don says no. Too much?
Were they hiding the fact that these were recent cars?
It's not that they were hiding it, but they,
It's a $2,000.
yeah, but so it's on them. It's like, you listen, you bought a $2,000 car, man. You should have known you were going to burst into flames.
There's liability. Sure.
Well,
And they gotta fix it, and they got their attention for sure.
oh yeah, he went in, he was like, this is a death trap. And they're like, you're funny, man. That's funny. Yeah, $2,000. I mean, that's a cheap car. But yeah, 125, and that's, you know, in the 70s, $125 million. We're sitting here talking about hot coffee in the 90s. Like that's $125 million in the 70s. I think it's pretty egregious though, what they knew about. It's not like they had no idea. You know, they did these tests and it was like, oh, it was just this fluke. A couple of them burst into flames, but we can explain this away. No, it was like, they knew it. Yeah, they were like, make it cheap, make it look cool. And like, but people will die. And they're like, they'll look really cool doing it. And they'll have saved a bunch of money, which their family can then use to bury them. But yeah, who knows? What would the free market approach to this, the Ford Pinto issue? Did you find out the inflation?
Oh, yeah, the $2,000 car, $8,023.99.
Yeah, I mean, $8,000 brand new. I'd take that risk. I'd roll those dice, but no, I'm just kidding. I don't want to spend a lot of, I'm just buy used cars. I buy used cars. But anyway, what would the free market approach? Looking at what would Friedman say about this? You're looking at this and you're like, hey, here's the design. It could kill people, but it'll make us a whole bunch of money. We'll save money on the design.
I don't know. I feel like that's pretty clear answer. This time I read.
Even Friedman is like,
People say, this is very unsafe.
no, like I'm thinking of this strictly from shareholder value. Like one lawsuit could wipe out all of our profits. So even Friedman's probably going to say, let's spend the extra $10, guys. Now Friedman might say, spend the extra $1.25 to put like the safety bumpers around the bolts that just stab into them. Bless you. It's some like, you got allergies or something? Oh man. You're allergic to this class, aren't you? But yeah, maybe Friedman would say, spend the extra $1.25 per getting nervous there, Don. Sneezing is not a thing, Corona thing, right? Turner, we know. I don't think it's a Corona thing. But yeah, maybe Friedman would say, spend the extra $1.25. I think everyone else would be like, spend the $10, universal principles, guys, come on. Obviously ethics of care would be like, cars are polluting the environment, don't buy cars at all, who knows? But yeah, I think everybody would agree. Ford they really screwed the pooch on. They've screwed that one up badly. That was not a good idea. So design is great. Make sure it's safe first when you're developing your products that you're going to make millions of dollars from. Safety first, then design, right? Let's compare Volkswagen versus Ford. Which one was more wrong? Yeah.
Immediate.
Yeah, people right on the spot burned to death inside a Ford Pinto, not inside a sweet car like a Ford Pinto. And just, man. But Volkswagen, their harm was to the environment. Like it was like causing huge emissions. They're defrauding customers, the people that bought these cars specifically because it was clean diesel and it wasn't at all. So the harm was less, but more widespread, maybe you could say, for VW. But it's that question of what do we value more, human life or, honesty in what we're selling? What? Yeah, the rights of Mother Earth. The Mother Earth people are obviously going to say Volkswagen's in the wrong here. Some people burn up, who cares? It's about Earth, man. But I think really, Ford, I would argue Ford was more wrong here because the harm was less in terms of overall number of people affected, but the harm to those people was obviously as extreme as harm can get, killing somebody, right? And from an ethical standpoint, though, free market ethics, what would they say? VW or Ford? Who's more wrong? That's a tough one, right? Yeah, well, they both lost a bunch of money. So Friedman's like, he's not down with either one of those, right? Or maybe Kant, universal principles. Okay. If Kant says the deontological approach, the hierarchy would be probably life would come above honesty and, pollution, right? So probably the deontological approach would be Ford was more wrong because life is, you know, that's in the hierarchy of universal principles. Preservation of life has got to be pretty high up there, right? I don't know if you all are, I've not read a whole lot of Kant beyond the textbook, so we're doing the best we can here. But let's see, well, what are our other utilitarian? Who's the utilitarian guy? Is that Milton? What's his name? Bentham, Jeremy Bentham, something like that. Bentham. Well, there you go, Bentham. And you're on top of this. So Bentham, utilitarian, you know, what's the least amount of harm, the least number of people, or the greatest, it's the greatest good, right? It's does the most good for the greatest number of people. Who's going to be, what would the analysis there be? Ford more wrong, Volkswagen more wrong?
I think you make a pretty good utilitarian argument that Volkswagen is more wrong. It's like affecting the environment, hurting everybody, I guess.
Yeah, I think that's a very, yeah. And again, with the ethical approaches, you can construct arguments. It's rare that you're going to be just absolutely clear cut one way or the other, except maybe Ford Pinto. Just looking at Ford itself, everyone's going to agree, well, Ford really did bad here. But I think that's a good, I think you could definitely make that argument that utilitarian approach is going to say, you know, maximize, you know, few people die from Ford Pinto, but a bunch of people had access to what they thought were cool looking cheap cars. Style has evolved. Everyone can look at the Pinto now and be like, that's a really ugly car. But I think you're right. You know, the Volkswagen that created more harm overall to more people. So these ethical analysis, isn't this fun? So back to products liability, breach of warranty. Now, what does caveat emptor mean? Buyer beware, right? It's Latin. The law loves Latin terms. Caveat emptor, buyer beware. And that was basically, again, except for that 1266 law that you can't sell adulterated wine and victuals, and who uses that word anymore? It was basically, hey, you bought it, buyer beware. You bought a crappy product. Maybe you should have, you know, tested it out a little bit before you used it. Of course, the seller tells you if you touch it, you buy it, but hey, buyer beware, you shouldn't have bought it. You know, it's on you, big guy. There was breach of warranty. That was the original way that you could get to a seller. Now, it was only to the immediate seller because it required privity of contract. Privity of contract is the concept that it is you actually engaged with another person to create a legally binding agreement, right? Privity of contract. And when you go and you buy something from a seller, you obviously haven't created privity of contract with the manufacturer of the product you purchased or with the wholesaler of the product you purchased, if there's a wholesaler. So it was very tough to prove a product's liability case prior to the 20th century. And that's, again, caveat emptor, buyer beware. That was the rule, right? Now, again, you had some exceptions, primarily for food. But to prove breach of warranty, which is the only way for a long time that you could get after somebody for harm caused by a defective product, was breach of warranty, which again required privity of contract. So you could only go after the immediate seller. Well, then Judge Benjamin Cardozo, way back in the day, early 1900s, in the McPherson versus Buick Motor Company case, you know, cars used to have wooden wheels. You know, imagine that's crazy. I mean, it probably wasn't a fast car, but a wooden wheel on a car. I know this was basically, they were like wagons without horses, and people were still probably like, this is crazy. My mind is blown, man. Where's the horse? But they had wooden wheels. And so this guy's driving around in his Buick with a wooden wheel that, of course, just explodes, sends him flying out of the car. And for the first time, this was on appeal, you know, he ruled that a plaintiff can sue for this defective wooden wheel. And he said that defects that could have been discovered by a reasonable inspection, but the inspection was omitted by the manufacturer. Well, I'm going to let the plaintiff recover here. And that was a first. That was new in the law, to say the plaintiff can recover against this manufacturer that could have investigated his product, could have discovered these defects, chose not to. Well, then the manufacturer is going to have liability. Now, Negligence, I don't think the book gives you a great breakdown of what negligence is, but negligence requires you really have to prove 5 elements. Duty, so you have to establish that there was a duty, that the defendant, the tortfeasor, owed a duty to the plaintiff. That can be in the context of a car wreck case. You have a duty not to run into other people on the road. And if you run into somebody else on the road, you've breached that duty. That's the second element. Duty, breach of that duty. And then proximate cause, which means that's legal cause. That's the breach caused this person to have suffered damages. Also, you have to have but for or actual cause, but for this negligent conduct, this breach of this established duty, I wouldn't have suffered these damages. And then finally, you got to prove that you had damages. So someone can wreck into you if you don't have any damages, then there's not really been negligence because you haven't been harmed. So in products liability, that requires that you show a product was defective or unreasonably dangerous, which they can counter, defendants can counter that by showing that they complied with industry standards, whatever the state of the art was. They say something, you hear that colloquially, people will say a state of the art, this pencil, this pen it's a state of the art pen. But what they really mean in this context, in the context of products liability, is it is the current state of the art. This is like the current norm for this, whatever the product is. That's the state of how these products are made, and people want to comply with that. They're not below it, if that makes sense. And then, of course, there's the standard defense to every negligence case, including products liability, is if there's another cause of the harm. If the defendant can point to, no, what actually caused your harm was this other factor, yourself or some other person caused or in part caused the harm you're complaining of. So that's traditional negligence. And then again, in the context of products liability, for a long time, you couldn't really do that except through breach of warranty claims, which are really contractual claims rather than tort claims. But Cardozo in the McPherson versus Buick Motor case, he says you can go after, for the first time, plaintiffs can go after manufacturers. Then in 1963, the California Supreme Court adopts what is known as strict products liability. And they quote here William Prosser, who says the public interest in human safety requires maximum possible protection. And that's kind of the underpinning theory behind it, is that, if we're going to protect public safety, one of the best ways that we can do that in the context of products liability is to say that manufacturers can be held strictly liable, which means you don't have to prove that they were negligent. They are just liable because harm was caused. You don't have to prove that they had a duty and they breached that duty, and as a proximate cause, you suffered damages. And the book quotes Restatement of Torts. Now, the restatements are basically legal treatises, however you say that, that, as they say, they restate the law in kind of simple formulaic fashion, with sections that address particular areas of the law. They have restatement of contracts, restatement of torts, restatement of damages. There are various different ones. A lot of courts will adopt the restatements, and there's actually a 3rd edition now, Restatement of Torts 3rd, and the courts will, not all of them have done it. It's not universal, but a lot of courts will adopt these sections of the restatement when they deal with a particular type of issue. And here, the book is quoted Restatement of Torts 2nd with respect to strict products liability. That says, one who sells any product in a defective condition, unreasonably dangerous to the user or consumer or to his property. So the harm can be to your person, the end user, your kid, or it can be damage to your property if it causes, your house to burn down. That person who sells the defective product that's unreasonably dangerous is subject to liability for physical harm thereby caused to the ultimate user or consumer or to his property if the seller is engaged in the business of selling that product and it is expected to and does reach the user or consumer without substantial change in the condition which it is sold. lawyers have a tendency to say things in a very long-winded fashion. What does that really mean? If you're a seller that typically engages in selling a particular product, and you sell it to somebody, and that product, because it's defective, causes some kind of harm to the end user, and the user did not alter that product in some way, didn't, like you sell, okay, you're a hardware store, you sell power tools, you sell a saw to somebody, like a circular saw, and it's got a little guard on them. They used to not have those. People started cutting their fingers off. Now they have guards, thanks to people like me, with labels on them that say, warning, this can cut your finger off. And you sell it, and for some reason that guard is so poorly made that the first time he uses it, it flies off, and the blade goes loose, and it lops his thumb off, and the blade goes shooting off into the garage somewhere. This happened with the Ryobi tool. There'd be strict liability there for the hardware store that sold it, because they are engaged in the business of selling the product, and it reached the user, the ultimate consumer, which again does not have to be the person that bought it. His wife got it for him as a gift, or his son is, not a kid, but is, like 16 or 18, knows how to work power tools, and it breaks on him. Then he'll be held liable if they haven't altered the product. Now, say the same thing happens, but there's not a defect with the guard. Instead, guy's in his little shop with his new circular saw, and he's like, I can't stand this guard. It's getting in my way. I'm taking it off. He takes the guard off, flings it in the trash. He's like, thank God, I'm a man. I don't need a guard. He cuts his thumb off. Well, if the guard would have kept him from cutting his thumb off, then the seller is not liable because the user has altered the product. Does that make sense?
So it's strict liability for the seller or the manufacturer?
This is the seller. Now, it's also the manufacturer, actually. I mean, it can they've dated it here in terms of the seller, but the seller there's ways for the seller to avoid liability. Like if they sell, the hardware store and you buy them, it's in a package, and they just get it from the manufacturer. They stick the box on the shelf, and that's it. And they stick a price tag on there. You go and you buy it. Seller's the ultimate seller, the hardware store is going to avoid liability in that case, because they can say, I didn't touch it. I got it in a box, stuck it on the shelf. They bought it. Whatever problems were with it was caused by the manufacturer, or was caused by the person messing with the product, right? They say it here, and that's why this case is from 1963. The restatement second, they've updated restatement third. They changed the wording. They make it less sounding like a lawyer in the 60s wrote it, but also they take into account like the big box stores that were in the early 60s. That wasn't nearly as common, right? Now you're going to Walmart, you're going to Ace Hardware, you're going to buy something that's in the box and it's there, right? Unless you're buying the display model, and then you might have, that might change the facts a little bit. But the restatement goes on to say that rule, strict liability for the seller of the product, applies even though the seller exercised all possible care in the preparation and sale of the product, and the user or consumer, did not buy the product from or enter into any contractual relation with the seller. And that's a way they can bypass the, buying it from the hardware store. You can say, I didn't have privity it's that privity of contract issue, right? So before you had that privity of contract to prove a breach of warranty claim. Here, defective product, strict liability. If you sell the product and the end user didn't alter it in any way and was harmed as a result because it was defective and unreasonably dangerous, they don't have to have privity of contract. They don't have to have engaged directly, so they can go to, because the manufacturer is technically a seller of the product. They manufacture it and they sell it, right? So that's a way that when the hardware store says, listen, it was in the box, we sold it to you, we didn't touch it, it's not, we didn't do anything wrong here. Well, that second part of that rule there says, even though you don't have privity of contract with the seller, and even though the seller engaged in the best, and exercised all possible care in the preparation and sale, you still get strict liability against them. Now, that's not Not all states have that, but most, the vast majority do. Does that, now this is does it make sense? Does anybody have any questions about this? This is not the simplest concepts in the world, but not the most complex either.
So it applies to the person who sold it, took the money, all the way up to the manufacturer. That's
Yeah,
a
it
separate
can.
thing.
Yeah, essentially. But again, as I've said, but the seller that just gets the box from the wholesaler, from the manufacturer, sticks it on the shelf, they're going to get out. They're going to say, listen, we didn't adulterate this product. We didn't change it in any way. Now, if they pull it out and it's the display model and they've been messing with it and they took the guard, one of the employees took the guard off to show a customer, hey, if you take the guard off and do this, then in that case, it'd probably be the hardware store and not the manufacturer that would get popped. So it's always fact, every case is going to be driven by the facts, but this is just kind of the general rule with strict products liability. That's the concept behind it. Now, there are three types of, I guess, defects in products liability cases. There are three main defects that courts will look at. Did you all pick up what those different types are? There's design defect, right? So what is meant by design defect? Yeah, that it is, the design itself is unsafe. The design itself is unreasonably dangerous. And, it's not that the next one is manufacturing defect, right? So the design defect says at the R&D level, you screwed up, is essentially what it's saying. Now, manufacturing defect is different from design defect. What is manufacturing defect? Sounds like means what it says, right? Yeah. Yeah, you made the bolts made out of some crappy aluminum, should have been made out of steel, and it breaks under the stress. It doesn't have the right tensile strength. That could be designed if it was designed that way. But if you get faulty part in the manufacturing process, something didn't get formed correctly, that's a manufacturing defect. The design itself was okay, but in the manufacturing process, they used a faulty part. If they'd used the right part, it would have been fine, but they used the wrong one. That's a manufacturing defect. You still get liability there. And then finally, what we've already talked about is failure to warn. And it's like there's the manufacturer is obviously going to be in a better position to know what its product can do, particularly anything that might go wrong with the product. So if there are any known warnings, they need to pass those warnings along and let the consumers know. There was a crossbow case, a case about not like a case that a crossbow goes into, but a case about a crossbow. I can't remember who it was. I've actually got a crossbow made by this company. And this guy was out hunting with his crossbow, and he gets it up on the grip here and he goes to shoot and he holds it and he puts his thumb up like this and it takes the top of his thumb off. Because those things are just like 350 pounds of pressure, right? And it goes, pow, goes really fast. And he just took the top of his thumb off and he's just like, I've lost the top of my thumb. And he sued the company and said, you should have put a warning on there, not to stick your thumb up. And boy, there's the deposition, it was videotaped. The CEO of that crossbow company was like, listen, the guy's an idiot. And he's like, let me show you. He picks up a crossbow and he's like, I'm hunting. The string's right here. I'm not going to put my thumb up above it. What am I, an idiot? He lost. And now there are warnings on it. It says, don't put your thumb above this. And what it tells you is, now this is one nice lawyers, but I'm with you. But a lot of times with these warnings, I don't want to say lowest common denominator, but you just think about your dumbest consumer when you're putting your warning labels on, right? Don't think the standard in the law is what a reasonable person would do, but a good lawyer can make reasonable people believe all kinds of crazy things, make 12 reasonable people believe crazy things. So when you're putting together these labels on your products that you're going to make millions of dollars on, think of your dumbest customer and put the labels on for that guy, right? And that would be an example of they would argue that's a design. No, that would be a failure to warn, right? It'd be failure to warn. But they actually did change the grip too, so that it's got like a, instead of just a regular grip like a rifle, there's actually a little groove cut out so you can grab it like this. There's another string goes on that. So there are two different kinds of tests when looking at that courts use. I think Tennessee is still a consumer expectation test versus the danger utility test. So consumer expectation test is, they both are pretty much what they sound like, which is if a product is dangerous beyond what an ordinary or reasonable consumer would expect, then you've established that it's a defective product, whether it's design or manufacturing or failure to warn. The idea there is, okay, what would an ordinary consumer expect from this product? Now with the crossbow case, you would say, I expect if I put my thumb up where the string is when I shoot it, that it'll cut my thumb off. But I guess nobody made that argument. That's the consumer expectation test. What would a reasonable consumer expect this product to do? And if it's more dangerous than what a reasonable consumer would expect from this product, you've got a defect. You've got liability. The other one's the danger utility test. Again, what it sounds like, if the danger of the product outweighs the utility of the product, they're going to say, okay, this is unreasonably dangerous. You've established a product's liability case. Most courts will use the consumer expectation test. I think it's a better test because there are a lot of products out there that are just dangerous by their very nature. And the danger utility test, that gives gun control people too much to play with. So I don't like the danger utility test. Danger outweighs usefulness. I mean, couldn't make that argument with cars. Cars are dangerous, but they're pretty useful. Same with tools, but tools can be real dangerous, like jackhammers. How you can hammer up the concrete, but that's like incredibly dangerous tool. And you can also just break up that concrete with sledgehammers, right? So why should we have that? I don't like the danger utility test. I think the consumer expectation test is more reasonable, and it's the standard rule in the law and in litigation and civil litigation is reasonableness. That's why I like the consumer expectation test more. I think it's the better test. Then the book goes into punitive damages and quotes Mother Jones, which is like, they make NPR look like fascists, Mother Jones is like just extremely left wing, which is okay. But they have this big quotation about gun manufacturers that's just kind of like crazy. I don't know, it's crazy. Complaining about laws that shield them from liability for crimes committed with their products. I mean, are these gun manufacturers making guns and selling to people and be like, you can rob so many people with this firearm. You can kill a bunch of innocents with our weapons. Is that what they're marketing these things as? No, you sure? No commercials where they've been like, no, they're not. They're not. That's insane. I think that Mother Jones, I wrote down in my notes here, which is like, what? Multiple question marks. I can't even, I drove it from my mind. I can't remember exactly what they said, but I remember being just like, does this have to do with products liability? Well, people say that guns are so dangerous that, only cops in the Army should have them. Well, anyway. There is a firearms law, the Protection of Lawful Commerce and Arms Act. And I can't remember, was that passed in the 90s or early 2000s? 2005, yeah. And basically, what's that law basically say? Yeah, well, really, it's a person who's been harmed by someone engaging in criminal conduct. You can't go hold the gun manufacturer or the ammunition manufacturer liable because someone has engaged in conduct which is already illegal, right? If they would just make murder illegal, it would solve the problem, right? So prohibits lawsuits against gun manufacturers for harm caused by criminal or misuse. And of course, they talk about, I think in 2017 was the most recent numbers that the feds have released, something like 39,000 people killed by guns. 2/3 of that was suicides. Something like 355 were killed by rifles. So it's really not, I make this big thing about scary assault rifles. I mean, it's terrible. It's horrible that people have died from them, but how widespread is it actually? Again, it's like the McDonald's hot coffee case. Media manipulation is a very real thing. So always try to find the facts, and journalists don't always do that. Everybody's got an agenda, and they've got a major one. So there's like Sandy Hook. I mean, this is, again, I'm a pro firearms person, right? I'm in Tennessee. I have to. I don't even have a choice. We have to. Not really. But that's right. But, you know, I don't want to minimize the harm that have been caused by people engaging in criminal conduct with firearms. Of course, people engage in criminal conduct with all manner of implements. I mean, you could stab somebody to death with a pen. You're not going to get very far. You know, someone's probably going to stop you by the first one. You can run people over with your car. That's happened. You know, you can get a truck and you can probably get into a crowd of people. You might be able to kill, 15 or 20 people. But, it doesn't minimize, guns are frightening to people, especially if they haven't been exposed to them. And it's like Sandy Hook. And the families at Sandy Hook, they've sued Bushmaster. They sued. I don't really know what's the status of that litigation is. But they basically said civilians are unfit to operate assault rifles, and they should not be marketed outside of specialized, highly regulated institutions like the armed forces or law enforcement. What do you all think about that position? Is that, do you think they're making a fair argument there?
Automatic weapons are.
Oh, they're very highly regulated, extremely highly regulated. Yeah. Yeah, I just, you're talking about a Bushmaster, AR, they call them, is the Bushmaster make the AR-15? I mean, they're all that style, but they'll give them different names. Yeah, I guess some weird name. But that's a semi-automatic 223, 5.56, right? That's a souped up 22 is, much more powerful than that, but essentially what the military is using are typically like the 308 automatic. That's a very different weapon. That's a much more powerful weapon. Then of course, there's also the question of the Second Amendment. We've talked a lot about constitutional amendments, right? We don't really talk about the Second Amendment. But there's a very good argument that, well, first off, who constitutes the militia, by the way? Does anybody know who constitutes the militia? Well, you three and me constitute the militia. All you guys over there, well, some of you might not be citizens here, but you might be this militia. And then women, if you are in the National Guard, you are also the militia. But we are all the militia. If you're over 18, you are the militia. That's federal statute. They don't say no militia. There are no militias. Yes, there are. We are the militia. Now, are they going to call us up? I wouldn't. Washington, new militias weren't reliable. They're terrible. They all leave at the first opportunity. Like, this sucks. I'm out of here. I'm going back to my family. But we are the militia. So, saying that these assault rifles should only be marketed to these specialized, highly regulated institutions. First of all, they've got automatic weapons. They got much bigger guns. Like, what are we talking about here? But also, I think the big point, and one the book conveniently or intentionally ignores, is that when you're talking about criminal conduct, do you sue Ford if somebody drives their car into a crowd of people and runs them over because he's a lunatic? Do you go sue Ford for, if that car didn't go so fast, people wouldn't have died? People don't need cars that go over 40 miles an hour, right? If someone, what would be another example here? I can't think of one, but there, would you sue? Yeah, would you sue Ford for somebody running people over? Yeah, somebody, pilot, takes his airplane and is like, you know what? I'm gonna crash this building, which has happened, right? Did anybody sue Delta or American Airlines or Boeing from that? No, that was because that was horrific criminal conduct. It doesn't, minimize in any way the harm that was caused. But in terms of liability, who should be responsible? Well, the argument with guns is they are a little bit unique, What are guns made for? What is their purpose? So we're saying they're not really misusing the guns. I mean, they're shooting them. They're made to shoot bullets, right? And made to kill things or to shoot things. And that's what these people are using them for. But when they're using them in the context of criminal conduct, I mean, guns aren't made specifically for criminal conduct, despite what Leonard Skinner may say. Saturday Night Special, great song. But and who would have thought Leonard Skinner would be gun control guys? But, it's holding manufacturers liable when people misuse their products, when people engage in criminal conduct with their products. Is that fair? Is that something we should allow? I mean, is the Protection of Lawful Commerce and Arms Act, should that remain on the books? There's a lot of politicians that don't like it. They want it gone. What do you all think? Yeah. I mean, it's an in run around the Second Amendment. Some people could argue. If we just get rid of the manufacturers, we don't have to worry about the Second Amendment because nobody can get guns, right? But, and there are like the fraudulent gun purchase one that they give the example of, where guy goes in with his girlfriend. He's a convicted felon. He goes up to the counter and he's looking at the gun. I'm like, sir, can I help you? And he's like, walks off. Girlfriend goes up. She's like, okay. He goes, I want the shotgun and rifle. Gets them. I'm not making fun of girls here. I'm just, this is kind of what happened in this story, right? Doesn't ask any questions. She's like, yeah, that one and that one. Pays a bunch of money, fills out the form, says, I'm going to use this. I'm not buying this for other people. Turns out she was. He goes and kills a bunch of people with these weapons. And they say we should hold the gun store liable. Now, the manufacturer, I mean, that's the same as Sandy Hook or any of the others. What's the manufacturer have to do with whether somebody takes this product and uses it for, to criminal ends? The gun store, I mean, should there be any liability there? Should they know? Yeah, I mean, well, should they know? You're saying, listen, you should know if she comes in when the guy's there with her that she's really buying it for him and he's a convicted felon. How are they going to know he's a convicted felon? How's he going to know that he was a convicted felon? He was helping his girlfriend pick out a gun. And, he was like, I'm not buying it. My girlfriend's buying one. Then he goes and engages in criminal conduct. Is it fair to hold the gun store liable there? And then, of course, and I think the Aurora Theater, and that gets more to online gun sales. Well, he bought not his guns. He bought ammunition, magazines. You can buy magazines, get them shipped right to your. I mean, I get ammo shipped to my house. I mean, I have never had ammo shipped to my house ever. Why would I do that? That's crazy. But he got high capacity magazines and ammunition all shipped right to his door. Body armor, right? Yeah. I mean, I could get a butcher knife. I could buy one off Amazon. I could buy a butcher knife off Amazon and then go stab a bunch of people. And then we're going to sue Amazon and the knife manufacturer, right? Because knives are made for stabbing and cutting, aren't they? Or for slicing meat, Guns are made for killing people or for hunting and for shooting and for target practice and for self-defense, right? So this is heavy stuff. But I think it's worth it. It's something that people need to think about, and there may be some arguments on the other side. I haven't really thought about them, but the book has a lot. So moving on to Stephen D. Sugarman, and that's why we're at 8 o'clock. I'm going to try to do we want to take a break or do we want to try to get through? We've still got to get through chapter 10 as well. What do you all want to do? Want to take 5? Okay, we'll take 5. We'll talk about performance-based regulation at 8:04. 8:04. Let me get some water. Okay, so performance-based regulation. This is Stephen D. Sugarman. What did he mean by performance-based regulation and what was he talking about? Yeah, he's saying set targets and have a penalty structure in place if these companies don't meet these targets. And of course, he's mostly talking about tobacco because what else would the book talk about? He's basically saying penalize them if they sell too much of their product, so they can only sell just enough of their product. And then he even suggests doing this cap and trade idea, where if they get enough people to quit smoking, they could sell the excess smokers to Philip Morris or whatever. And as Don told us a couple of weeks ago, cap and trade just doesn't work, right? Would it work in the context of smoking?
Well, in California, they said it's a very thing. But everything's expensive out there.
Oh, it's California's just perfect, right? Everything's just so great. That's why God hurls lightning bolts at it and catches half the state on fire. That was great when it was like the wildfires, like what caused it? And it was like actually an unprecedented number of lightning strikes in a concentrated area. And I was like, oh, you mean God is pissed. That was great. I learned that and I was like, oh, California, they deserve it. It couldn't happen to a better state. But I'm sure California is great, but not that great. But anyway, so Sugarman's performance-based regulation. I mean, what do you all think of performance-based regulation? Do you think it's something that would be effective? Do you think it's something that would be fair? Socially efficient prevention. They're saying just taxing it and making it harder to do it isn't working. So let's make the companies do it for us. Yeah, let's make them put that. That'll really, they will be totally on board. Like, this sounds great. Reduce our profits, reduce our customer base. And you make some fair points. So like, hey, you'll still get your heavy smokers are still going to be buying, just pack after pack of cigarettes, right?
And you can still sell some of your stuff, it's not cheap.
Yeah.
You can sell like 100,000 cars.
Yeah, and that's with that, because pollution's a serious issue, right? So you can only sell so many cars. You think that would fly? Now, for about 10 seconds, 0 seconds. But with tobacco, oh, it's totally fine. This is another one of those kooky ideas that the book is pushing forward. And I mean, I don't really see it happening. And I don't think it'd be very effective. What? Yeah, that's sounds about right. It's you have like crazy hair and all that. Right? The law professors are usually a lot more clean cut. They're not quite as it's just crazy looking. Like who's that guy from? He's a Harvard professor, and he's just real. He's on Hannity a lot, and he's just like he looks crazy. Makes some good points sometimes, but only sometimes. So moving on to more important topics than performance-based regulation. I don't know. I maybe made some good points on your heaviest smokers will still smoke. My uncle, when he died, this is back when Marlboro, you could get like tickets from each pack of smokes. And if you had enough, you could get a jacket or luggage or whatever. When he died, he had a trash bag full, a black trash bag full of not packs of cigarettes, just the tickets. He smoked all the time. It was crazy. He would have kept Marlboro afloat if they'd done the performance-based regulations, like by himself. He put the team on his back. But so on to more important topics. Uniform Commercial Code, the UCC. Now, this actually is adopted in every single state, and it governs the sale of goods. And it's pretty important, pretty simple. In the grand scheme of things, it's a fairly simple statutory scheme, but it applies, and it was originally, created in 1952. It's been adopted in every state. There are implied warrant. The most important topics for purposes of this class are the implied warranties There's the implied warranty of fitness for ordinary purposes, also known as the implied warranty of merchantability. And essentially what that says is this product, by selling this product, unless they expressly disclaim that warranty and say the implied warranty of merchantability expressly does not apply to this sale, they don't say that, then you have an implied warranty that the product you have purchased would be fit for the ordinary purposes for which such a product is used. An example of that might be a kitchen knife that is made for chopping vegetables. And no matter what you do, it can't get sharp and it won't chop anything. And it's basically just a metal bar, right? You'd have a fairly good claim for a breach of the implied warranty of merchantability. There is also the implied warranty of fitness for a particular purpose. And we look at that in the Kent Wool Company versus NetSuite Inc. case. What happened in that case?
They said their software could integrate all this different stuff, and they could make it happen for $2,000 or something.
Yeah, so it's, yeah.
Get it to that point.
Yeah. That's essentially, it was Kent Wool was a textile, in South Carolina, they're a textile manufacturing company. They make, I guess they just make the actual cloth. I don't know if they made, shirts and pants and stuff, but they're a textile manufacturing company. And they got this, and NetSuite was going to sell them software that would integrate their sales, their inventory, their shipping processes. It was going to be the whole 9 yards. It was going to do it all in one big computer program that was going to just make it a lot easier to manage the actual numbers of their business. So you had both, arguably, an implied warranty of merchantability, that this software would be fit for its ordinary purposes, that it would work to manage their inventory and all their sales, et cetera. And also implied warranty of fitness for a particular purpose. Fitness for a particular purpose applies when the seller, or when the buyer is relying on the expertise or representations of the seller that the product he's going to purchase will work for a particular purpose. I need this product to do this particular thing. So in the context of like buying a car, okay, I need to go. Now, ordinary purpose would be you're buying a car and it's able to drive. You can turn it on and it'll drive along the roads and the brakes work and it's a car. But you go and you say, I need a car. I'm going to be doing some off-roading. I need a car that can handle that. And he says, okay, this car right here, you can go off-roading in this thing and it'll handle it just fine. And then you go out and it turns out the car drives on the road fine, but you go off-roading, four-wheel drive doesn't work. It's just no good for off-roading. The clearance isn't high enough, whatever it may be. Then you'd have a claim not for a breach of the implied warranty of merchantability, but a breach for implied warrant claim for a breach of the implied warranty of fitness for a particular purpose, because you relied on the seller telling you this truck will work or this vehicle will work for off-road purposes. Well, that's what they did here in this case. Is we need a product that will allow us to manage all of our books and records and all that with sales and et cetera. And we need to do it all. And they say, this product will do it. This software will do it. Now, of course, the case, they go in, we're introducing the UCC in the context of these implied warranties, merchantability and fitness for a particular purpose. And then it turns out they don't actually apply in this case, which the book does. This is not the first time the book has done this, where it's like, so this isn't an actual case about this. Is a case where this doesn't apply, but that's great. We still get to talk about it. What actually happened and the reason why did it not apply in this case? Why did the implied warranties? Why could they not establish breach of those warranties under the UCC?
So the implementations, costs,
So it's around back itches. Man. So what the UCC applies to the sale of goods. What their contract with NetSuite Inc. involved was both the purchase of software as a good, and software is kind of a unique, it's kind of goes both ways, so to speak, but it's also services. It's goods versus services. So NetSuite both sold them the software and said, we'll maintain it, will handle updates to it, will help you, implement the software in your systems, and will basically help you run it. So they weren't just selling them the software and you like selling you Windows 10 and you pop it into your new computer and install it and you're on your own from there. They were actually providing services in addition to the software. So the court looked at the factors involved, said, okay, this really involved more services than goods, because NetSuite was going to be involved in implementing the software, updating it, making sure it works properly. So they say UCC's out because the contract was primarily for services. Software is always going to be kind of a question. It can be goods. It can be primarily goods. You buy Windows 10 to install it in your computer. That's goods, because they're not going to come in and install it for you and run it for you. But here it can be services if there are services attached with that software. They're helping you implement it. And again, with software, it's kind of in that middle ground. Usually it's one or the other. You go to the hardware store and buy a tool, UCC applies, you purchased a good. You hire a contractor to come in and build you a deck, that's services. That's a contract for services. UCC won't apply. Does that make sense? So here, court says ultimately it's more services than goods. The service predominates, so it dismisses the UCC claims, but the breach of contract claim survives, because a breach of contract is much more simple than, you don't have these specific provisions. It says you promised to do X, I performed my end of the bargain, I paid you money, you failed to do X, you've breached the contract, I've suffered damages as a result. So does the UCC ever cover software sales contracts? Yes, I think I pretty much gave you the answer to that already. Depends on the nature of the contract, what you're purchasing. If you're just buying the software and you're going to write yourself, UCC will apply. If you are buying software and the company is also going to help you implement it, help you use it, help you run it, it's probably going to be services. Services will probably predominate, meaning the UCC will not apply. Now, in contract cases, so there's different categories of damages depending on what kind of lawsuit you're talking about, right? In torts, you've got a pretty wide range. You got consequential, you got special damages, you've got pain and suffering, loss of enjoyment of life, other non-economic damages, you got potentially punitive damages. There's a whole lot of different damages you can have. In contracts, you're a little bit more limited. You got general and incidental damages, and that's basically what the injured party expected from the contract, or your general and incidental damages. So you expected to get X, they breached it, you didn't get X, your general and incidental damages are going to be that. Those are your what you expected to get from the contract, essentially. You also have what are called special damages and consequential damages, and that's a good way to explain that or describe it would be that is what the injured party experienced from the breach. So you expected to get, whatever you're going to get from the contract, those are your general and incidental damages. And then you experienced harm beyond that, injuries beyond that, those are special and consequential damages as a result of the failure of the NetSuite software and the failure of them to implement it correctly. Kentwool loses out on a bunch of sales. They lose a customer. And that would be special or consequential damages as a result of, as a consequence of NetSuite breaching the contract. Kentwool loses a customer. That'd be an example. Now, the general and incidental damages would be they paid all this money, didn't get the service they were promised. Their general and incidental damages are the money they paid to NetSuite. Less probably, the cost of the actual software wouldn't be the whole contract amount. Now, the book says you can't get pain and suffering and those types of damages in breach of contract cases. That is most certainly true. It also says no punitive damages. That's not always true. A breaching party can breach a contract in such an egregious fashion or such a malicious fashion that punitive damages could potentially be appropriate. Not typical, in fact, quite rare, but it's not true to just say as a blanket, you don't have punitive damages in contract cases. They're rare, but it can happen if the breaching party has engaged in malicious or fraudulent or intentional or reckless conduct in Tennessee. That's standard different in other states, but it's basically that. Let's see. And that wraps up the products liability chapter. And of course, UCC, that's not, it's implicated in products liability, but it's kind of a separate, also its own separate thing. Obviously, the Kent Wool case wasn't a products liability case, it was a breach of contract case. So they kind of mashed together two very different concepts of the law. In law school, you would take torts class, you wouldn't talk about breach of contract, and then you have contracts where you don't talk about torts. Those are two distinct areas, but they can overlap. Does anybody have any questions about Chapter 9, about products liability, the UCC, or breach of contract cases? Okay, we're gonna move on to Chapter 10, intellectual property. Pretty exciting stuff here. Intellectual property is a major component of the United States economy. I think everybody knows, manufacturing is, there's not nearly as much manufacturing going on in the United States as there once was. We don't produce nearly as much. My chair, come here. My short little legs. We don't produce nearly as much physical goods, manufactured goods as we used to, right? Cars are made in Mexico, hoverboards are made in China, and burn people's houses down. But we develop a lot of intellectual property. And that's both. Intellectual property is a pretty broad umbrella. Pretty broad. It's actually pretty clearly defined. What are the three major types of intellectual property? Major categories of intellectual property, we'll call it that.
Copyright.
You got
trademark,
copyright? Mhm.
And invention.
Well, wait, you're the engineer. Come on, what do they call it?
What?
Patents.
Patents, right.
Yeah, patents, which is inventions, right? So, and we'll start with copyrights. Now, of course, and I will say that IP is a major component of the modern U.S. economy. That's software, art, music, inventions that will ultimately be made in China or somewhere else and then shipped over here to avoid having to pay fair wages, which we require by law here. And that just ends up, we'll go where they don't pay fair wages. But we've already talked about that. We've also had issues with massive international theft of intellectual property from this country. It's happened a lot with India, and of course, my favorite bogeyman, China. But and it happened. I mean, it's very real. It's there. You can't deny it. It happens. But it's also caused a lot of issues for a lot of companies that develop this intellectual property, and then it just gets stolen and sold for pennies on the dollar by other countries who reap all the rewards of these people's hard work and development, and without having to do any of it. And they just steal their designs and then don't even make them as good as the designs made them. But anyway, again, that is what it is. So we'll start with copyright. Now, copyright covers, that's basically, copyright is the area of art, music, literature, movies. Those are all, that's kind of under the umbrella of copyright, right? So you've got, and with music, we do, and we'll get a little bit into, we've got a case to look at, but Spotify and Apple and all that, they've kind of taken over the Kazaa era. Music is not nearly as profitable as it used to be for a lot of songwriters. There was a few years ago, there was a song, I'm All About That Bass, some terrible song. It was like a big hit. People loved it. I didn't love it, but a lot of people did. The guy who wrote that song testified to Congress that in #1 song, if you wrote a #1 song in the 70s or the 80s, you were a millionaire overnight. They'd have a big party for you in Nashville, and you'd go buy your new farm and a mansion and all kinds of crap and go bankrupt 10 years later, unless you wrote another #1 hit song. Guy that wrote that All About That Bass #1 hit song of 2000, whenever, 15 or 16, made $4,800. So who the hell's going to write songs anymore, right? Just do it for fun now. So that's one of the unfortunate realities of what's happened with streaming and with online digital. It started with Kazaa and Napster and theft basically of songs. And then you had the guys from Metallica, and everyone revolted against them because they said they sued a bunch of people and were like, you need to pay us for our songs. They're like, how dare you demand money for what you've done? But that's kind of, music is not, you're not going to have people like Paul McCartney, people that are that talented. They're going to want to make money, so they're going to do something else. They're not going to write good music. They'll do that in their free time. But anyway, Copyright Act of 1909. And it basically just, enacted this to just say that copyrights which attach to whatever you've created, they attach immediately. So you write a song, it's copyrighted. Now you put your little C on it to get it registered. There's a registration process for it, and it's advisable to do it because it puts the world on notice, and it makes it a lot easier to sue people for stealing your work. But copyright attaches immediately. You write a song, you paint a picture, it's copyrighted. People can't just go steal it and use it for their own profit. But it has to be original. And for it to be original, that requires independent creation of the author, and it has to involve at least minimal creativity. And how do you determine that? That's very much a case-by-case determination. We got the song Bridgeport Music versus UMG Recordings. That's George Clinton, Parliamentary Funkadelic, P-Funk. I had a friend whose dog, he named his dog P-Funk. I never really listened to their music, but basically this song was Atomic Dog, which was one of P-Funk's big songs apparently. And it had this bow, wow, wow, yippee-yi, yippee-yay was the chorus to it. And then this guy wrote this song, D.O.G. and Me, and it had this kind of like, it would like in the background, like bow, wow, it would basically just rip the chorus from it. Filed a lawsuit. And I think they ended up winning that case. Did P-Funk or his I guess the owners or his studio, I don't know what the ownership structure was there, but they ended up showing that, listen, it's not just that you said dog in the chorus, it's how you said it in that low tone, it was the most recognizable recognizable part of his song, which was one of his most famous songs. And then they turn around and they basically just ripped it for their chorus. They took the most recognizable part that was unique when you looked at all the factors together. It's the, low registry of voice and, saying dog, and kind of the structure was very similar. How similar? I mean, I listened to both the songs last night. You can hear it, but it's a lot of these copyright cases, unless it's a slam dunk, you're going to go to trial and the jury's going to sit there and listen to one and listen to the other. And you can probably be pretty sick of those songs by the end of the trial. Another one was Robin Thicke. What was that song? Oh, it's like Blurred Lines. And it ended up he was like a total creep. And I was like, really? You didn't realize that after you watched the music video of Blurred Lines? That he was just totally going around molesting people? But Marvin Gaye's heirs sued him because he basically just ripped, I can't remember which song it was, but some Marvin Gaye song that they absolutely listened to him. And it's like, oh, yeah, that's like the same song. And they just totally stole it and just sort of changed the lyrics to it and made it a little bit more upbeat. And I think they got hit big for that. And had that other, who's the guy with Robin Thicke on that one? Somewhat more famous than him. But anyway, these songs, they don't have to sound exactly the same. You can just get relatively close and you'll probably get hit for copyright infringement. So that's, again, copyright it can be writing, it's novels, artwork, music. Now, trademark, you get into logos. It's interesting. Logos can both have copyright and trademark attachments to them. We'll talk in a minute about trademarks. But with copyright, again, it attaches immediately. You can register it, and it's good to register it, but you don't have to. You have copyright regardless. As soon as you've created something that's yours, that's original, that's your independent creation and involved at least minimal creativity, you've got copyright protections on it. You can put your little C with the circle around it. And you'll see a lot of products, they'll have the R with a circle around it. That means rights reserved. They'll usually do that when they've got a pending trademark application. And it also encompasses, okay, we're reserving our rights with respect to copyright, with respect to trademarks, and potentially patents, usually not though. So the book asks, when Shakespeare would basically just take stories from Plutarch and he would just wholesale copy them and just make up his own stories using the same facts, and the same, basic premise or moral of a story from Plutarch. I don't know why the book brings that up, because copyright, the way copyright exists, how it works, is it's the life of the author plus 70 years. So Mark Twain, I don't know, he died, 1910? I don't know when he died. That'll be on the exam. No, I'm just kidding. Mark Twain writes Huckleberry Finn. He died, let's say he died in 1910. That would mean the copyright expired in 1980. And after that, you can just wholesale copy Huck Finn all you want. It becomes part of what's known as the public domain. So with copyright, it's life of the author plus 70 years. It's a fairly long time, but it's the same for, music. And now that's in the United States. Copyright laws vary from country to country. Jamaica, it might be, and I'm not sure if that's copyright or I think it's copyright where it's life of the author plus 100 years. It can vary from country to country, which can create, some difficulties for people, where you might have something that would be in the public domain in the United States, but then you go try to sell it Jamaica or some other country, you might get in trouble for copyright infringement. But that's life of the author plus 70 years. That's how long copyright protections last before something then enters the public domain. So with Shakespeare, I mean, Plutarch was obviously dead for like 1,500 years before, or maybe 1,300 years before Shakespeare started writing his plays. So I don't know why the book brought that up, but I don't know why the book does a lot of things. So Napster and Kazaa and this question of sharing versus theft. And I don't know if you all, when I was in high school, this was big. Not that I ever did it, of course. But Kazaa and Napster, you could just download, people just upload their CDs, and you just download all kinds of stuff, just all kinds of P2P, peer-to-peer. I don't know what that means. P2P, I think, means peer-to-peer. But you could basically, people could share their music or their movies, and you could just download them. And you could download movies, all kinds of stuff. It was just widespread theft of intellectual property is what it was. In the book, it's this article from a feminist, what do they call it? Like feminist copyright or feminist intellectual property was kind of, feminist interpretation of intellectual property. And she's talking about knitting, which seems super sexist to me. I was like, what are you, feminist? And you're talking about knitting? That's ridiculous. But she makes this point of, it used to be that knitting, people would, primarily women, would, again, super sexist, but would learn knitting from they'd share patterns with each other. Be like, oh, I got a new pattern. Here, you take this pattern, you learn it off of that. And now you had people, mostly women, would now copyright these patterns where they'd take those patterns, say, these are mine. I'm going to sue you if you use these patterns because I want to sell them and make money off of them. And they would sell books full of patterns, right? But I think she kind of undercuts her own argument when she says, women will take these patterns and then tweak them, make them their own. They're making the pattern. I'm going to do this a little bit differently. I'll add a different color here. I'll add a different needle stroke. I don't know how knitting works, but I think that undercuts her argument a little bit, mainly because you're not just like, okay, I'm going to copyright, this song, and you can't share this song, you can't play this song to people for money. Well, there's creation going on with knitting. You're providing a pattern, but then the person takes that and actually makes something, as opposed to you write a song and then I go, pick up my guitar and play it in front of people and make them pay me money to listen to me play, which no one would ever do. That's not the same thing. I'm not actually, unless I make changes to it, make it a unique, I'm going to add in different chord progression or whatever. I'm just copying. Here, if they're actually creating something from a pattern, I think there's a good argument there that, how much, I don't know. And she makes some good points, but also makes some points that I think are, that's kind of defeats her argument that they're creating something and they're changing it to make it their own. It transcends the pattern, right? And then, so again, you don't have to register to have copyright protection, but if you want to sue, you need to register. But again, the right, as soon as you've created something, copyright attaches. So there's what exceptions to the copyright law. The big one is fair use. Fair use could be, like if I pulled up a music video, of course you pull them up and you just have to watch an ad and they get paid through the ads. That actually doesn't matter. But, it's like articles or taking a section of a book. I could copy, chapter out of a book and pass it out to you all and say, read this chapter for class for educational purposes. That would be fair use. If you're doing it for education, commentary, scholarship, future artistic innovation, basically anything that advances public purposes without unduly diminishing the market for the original work constitutes fair use. Now there's the Sony BMG music case versus Tenenbaum. And that guy argues fair use. What was he doing? And what was he doing in that case? Yeah, was it Kazaa? Yeah, it was Kazaa. And he said, I didn't make any money. It's fair use, man. I'm sharing it to the world. I want people to hear all this great music that I listen to. Well, what does the court think of that argument? Yeah. They say, so you think fair use is basically, well, as long as I don't ask for any money, I can just willy-nilly steal whatever intellectual property I want and hand it out to people for free. It's for the public discourse. No, the court did not think very much. He said, you just want to say that fair use is basically, if you don't make money, it's fair use. And that's not at all true. So Section 107 of the Copyright Act, I think it had a specific name, but we'll just call it Copyright Act. Section 107 basically looks at 4 non-exhaustive or non-exclusive factors that you look at and determine whether there is fair use. You look at the purpose and the character of the use, including whether it's commercial or nonprofit educational. So here, obviously, this guy wasn't making a profit, but was he doing it to educate people? No, he was just sharing to his buddies all of his music. You look at the nature of the copyrighted work. So is it something that has a lot of commercial value, or is it something that's, it's like a crappy drawing? That's copyright. No one would buy it though. If it doesn't have any commercial value in and of itself, then sharing it there's not what damage is there, right? You also look at the amount and substantiality of the portion used in relation to the copyrighted work as a whole. So again, that's, if it's educational, you can pretty much use the whole thing and you're fine. But, if you're using a snippet of a song and your YouTube video that you've got, your YouTube channel you've got up there, it could be a close call. If you're just using a snippet of it, you can't really identify what it is. You just got a power chord from a Metallica song. Who knows what song it is if it's just one little clip of it. But if it's like a whole riff off of there, maybe you've got some problems. And then the effect of the use upon the potential market for or value of the copyrighted work. So essentially, if you have taken away the market, you're sharing enough of the song that people can get their fix listening to the song just off of your YouTube video while you're, filming yourself doing something. I don't know, people watch YouTube videos of everything these days, but people can sit there and listen. They really just want to listen to the song and they don't have to, pay the artist to listen to it or listen to ads to listen to it. They can just watch your music video, your YouTube video. Then you've probably impacted the potential market for that copyrighted work. And the court also identified several non-statutory factors. Some of them, they're kind of weird. I don't think, and it's like the assumption of risk. You basically, I think this was what the Tenenbaum was arguing. It's like, hey, you make this stuff and put it out there, you assume the risk that someone's going to steal it and sell it to other people, which is a pretty crappy argument. But, hey, he was desperate. He was facing some major liability. So you just throw it all out there and see what sticks and hope for the best. I can't really blame him for that. Marketing activities and failure to respond. So if you're if you're not marketing your work a whole bunch, or if you're failing to catch other people that are using your work, he's arguing, well, you shouldn't be entitled to all these copyright protections if you're not actively and aggressively pursuing protecting that right. Again, that's one that, how are you going to, until you know about it, can you say, well, I haven't scoured the internet to make sure nobody's using it, but there are people that are doing that. Prince's estate, they're doing that. Every day they're searching that YouTube, make sure nobody's got any Prince songs up there. Availability of paid alternatives, look at policing costs. So, and I think that ties back into the, failure to respond. Come on, you can't expect them to just spend all their time. You write one good song, maybe you want to write some more and not spend all your time trying to make sure no one steals your one good song that you've written. And then the injustice of the action. And here, I think with Tenenbaum, the court does say, listen, Congress needs to address this. Obviously, we can't have college students facing massive liability for, doing something that a substantial number of them were doing, probably without realizing. A lot of them did it without realizing exactly the extent of what they were, the wrongness of what they were doing. But he says, listen, this kid loses. He was just stealing money willy-nilly, claiming it's fair use because he didn't make any money. Sorry, but somebody's got to pay for this stuff. He's the sacrificial lamb. Shouldn't have been uploading all your crap on Kazaa. And now Kazaa is not around. I don't know if that's even around anymore. Probably not. But we've got Spotify. Who needs it? Spotify, YouTube, and Netflix. Now we just pay $10 a month. And artists, again, make $4,800 a year instead of $1 million off their number one hit. So hopefully there'll still be good music, and there still is, but just not as much. So again, public domain, the Creative Commons, that's this idea of, there should be protections for intellectual property, but there should also be accessibility. People should be able to use it. The purpose of this intellectual property, particularly with copyright, not so much trademark and patent. That's more, kind of economy related. With copyright, the idea is that you're increasing the kind of the breadth of human culture. You're increasing the breadth of human creation and of the things that make us more than just robots or animals. But this guy, Lawrence Lessig, I think I spelled that right. He's basically said that technology has made copyright laws stricter. He said, and technology has been used to intrude on or infringe upon the public domain. It's enabled because he made this point with, books. You've got a physical book, and there are copyright protections to it. But once you buy the book, you can go rip the pages off and do whatever you want with it, and then do all kinds of things with it. And he's talking about, I think he was the one that was talking about like his Adobe Reader. He can't even, books that were written 200 years ago that are clearly in the public domain, Three Musketeers or whatever, obviously in the public domain, right? But he can't, he's got this Adobe ebook reader that says, okay, you can read 10 free pages, but then you got to pay us. He says, well, wait a second, there's no copyright protection for this book. You're profiting off of the public domain. You've restricted the public domain. And that's always been the conflict within intellectual property. And again, particularly with respect to copyright, is you want to have as much accessibility as possible for the public domain, because that leads to more creation. Every work of art, every work of literature, they've all built off of something that came before them. But you still want to be able to protect, to as reasonable extent as possible, the people who created these works and their interest in those works. That makes sense? So, and we've got the Lens versus Universal Music Corp. This is the Prince's estate. This case, the mother was filming her child on YouTube, right? It was like a 29-second video, and the kid dancing to some Prince song. He's like, do you like the song? And the kid's like, oh, you bet, Prince is the best. And then Prince's estate is like, you take that video down, you thief. And I was just like, relax. But no, they weren't going to do that because, Prince's, they've got to protect all that sweet, sweet money that whoever his heirs are. I don't know if he had kids or what, but a bunch. I don't know, did he know? But like a spreadsheet or something.
It's crazy to have a person whose job was to search YouTube.
Oh, yeah. And they probably paid him good money too. And just to search YouTube, and it's, CSEC, there are three major, there's BMI, CSEC, and then there's one other, ASCAP are the major publishers for music. And they actually hire people to go around to restaurants and go in, you order a meal and sit down and you just listen. And if they're playing music, not from the radio, but just like playing a playlist, and they're playing their artists are within your portfolio, CSEC, and again, they're going to be BMI, CSEC, or ASCAP. If they're playing, CSEC's a lot of gospel music. I mean, they're playing, oh, that's Aretha Franklin. You're like, they come in, they send them a letter, the next week and say, you owe us a bunch of money because you've been playing her songs and not paying royalties. And a lot of restaurants don't realize it. And it's usually restaurants and, department stores and things like that. There are people that's their job, is to go around and find people that aren't paying royalties for playing music over the loudspeaker. So that's something to keep in mind. You open a retail or restaurant business or something like that. Don't think you can just throw your Spotify up there and be like, I pay $10 a month to Spotify. You got to be careful with that kind of stuff. That's again, why don't sharks eat lawyers? Professional courtesy. But I think I got that joke right. But anyway, it's out there. But what did the court say? Fair use came up in this Lenz versus Universal Music Corp case. What did the court say? Or what was the issue here in this case? Yeah, it's basically that they didn't consider fair use. They just said, you're taking our, you're stealing our music, you've infringed, take it down or we're going to sue you. And then, but they didn't even bother to say, oh, by the way, we need to investigate whether you've engaged in fair use, which is again, non-commercial, educational purposes, whatever it may be. And maybe she didn't have a good argument for it, but they didn't even consider it. And the court says here, listen, they failed to consider fair use and they knew it. You've got to have, as the holder of the copyright, a good faith belief that the alleged infringement was not fair use. Here, they didn't even bother to consider fair use. They just said, you're using Prince's music, take it down or pay us money. But, Google and Project Gutenberg and a lot of art museums, this is the good news about the public domain. We talk about like technology has restricted intellectual property in a way, or kind of made it too stringent. But you've got Google Books, Project Gutenberg, various art museums are making works of literature and works of art. You can download them. You can look at them on the internet, ones for which the copyrights have expired, which is good. I read books on Project Gutenberg a lot. I recommend it if you like, reading old books. You can just go and you can read them, the whole damn thing right there. You don't have to buy them. So they're nice. It's good. It's a good thing. Does anybody have any questions on copyright, fair use, any of that? Okay, so we're moving on to trademarks. And here we start with this Wyeth versus Samsung and Deutsch Association, which is the Wheel of Fortune lady, Vanna White. Anybody remember what this case was about? Yeah, so, and had a wig and pearls on and a dress. What is a robot, right? This is like in 1992, and they're like, this is what it'll be like in 2010. Like, no, not even close. In fact, that same lady is still doing Wheel of Fortune. She's still there. Plastic surgery has come a long way. I shouldn't say that. I don't know if I don't watch Wheel of Fortune. I'm sure she looks great. But there's an ad for VCR, which is like that in and of itself is hilarious. Like, if you all even know what a VCR is, Don, but rest of you ever seen one, right? The hell's a VCR? But so basically, now what was well, I mean, come on. I remember VCRs too, Don. It's no big deal. There's no need to be ashamed of your age. But what did the majority rule? And this is the Ninth Circuit, which is the Looney Tune land of the circuit courts. What did they rule? What did the majority rule in this case? It's well, okay. So the actual and it's misappropriation of name and likeness is sort of this weird hybrid tort and intellectual property. It's more tort than intellectual property, but it's misappropriation of name or likeness. And that basically says, you are taking this person's name or their likeness or something that's unique about them and using it for profit. So what the majority rules here is basically, hey, this wasn't parody. It's not like when Hustler did a satire of Jerry Falwell. When he sued him, he got all mad about it. But they were like, nope, this is clearly satire protected under the First Amendment. They can make fun of you all you want. Sorry, nothing you can do about it, Mr. Falwell. And Hustler continues they got to produce dirty magazines with comics making fun of Jerry Falwell. Here, the Ninth Circuit says, no, Samsung, it's the difference between parody and knockoff is the difference between fun and profit. And they said, you've made money off of it. Clearly, you're referring to Vanna White because she's the robot's next to Wheel of Fortune and has pearls and a dress. So you've misappropriated her likeness, you've reminded people of her, and that's enough. They say that's enough. Judge Kaczynski, relatively famous, he got in some trouble a couple years ago, around the same time as Kavanaugh. And interesting, I got a story about him. I actually gave him a ride from the UT Law School to the airport, and he brought up Playboy like just out of the blue. I'm riding, Judge Kaczynski, this guy's like the IP, he's all about IP. And he's just sitting there in the car, and I'm like, so what do you think of the conference? He's like, yeah, love this article in Playboy from 1980. It's this great article. I'm like, Playboy? What is he bringing this up? And he just went on and on about it. This great article about computers and Playboy. I'll send you a copy of it. And I'm like, please don't. No. Just get on your plane. Thank you, sir. Pleasure meeting you. It was really weird. And then I find out he got in trouble for like alleged sexual harassment of his clerks. I'm like, he did bring up Playboy to me one time, the only time I met him, and he brought it up. I did not bring it up. But anyway, he actually writes some really good opinions. That's just my Kaczynski story. I have to tell people, it's like, I don't have many opportunities to tell that story. So, but he wrote in his dissent, essentially that they're reducing too much to private property. Now, he says reducing too much to private property can be bad medicine. Basically, the majority's opinion was too aggressive. They've taken misappropriation of name and likeness too far. With name and likeness, the concept behind it, the basic idea is someone's name or like their actual picture or a video of them, their actual likeness, a painting of them, a representation of them, not a robot as them. I think the majority made the comparison of like, oh, if you put a Bulls jersey with a 23 on it, and it had an extended arm with a tongue sticking out, and it's like, robots don't have tongues. What's this guy talking about? But he said clearly it'd be, if you had a discernible pulse, you'd know it was Michael Jordan. It was still a robot, but, and that's kind of Kaczynski's point. And he says overprotecting the intellectual property is just as harmful as underprotecting it. And that they're expanding the right, the majority is expanding the right of publicity to anything that evokes this person's personality. And of course, these people are in California, makes sense. They're all in the pockets of these Hollywood elites, right? Maybe, I don't know. The conspiracy theorist to me says yes. So, and he says intellectual property laws protect only against certain types of appropriation. And, he says, we call this creativity, not piracy. He's like, there's got to be a limit to intellectual property protections. You're going to reduce the impact of the cultural value of intellectual property when you protect it too much, when you're too aggressive in protecting it. Again, misappropriation of name and likeness isn't really, it implicates intellectual property to an extent. It's not really its own kind of piece of intellectual property. it's more of a tort. But it's in there and it makes sense in the intellectual property chapter, so they just threw it in there. I don't know if these people are lawyers or not, who knows? So that's, anybody have any questions on misappropriation of likeness or names? Don't do it at Ninth Circuit, you know, you get in big trouble, but around here it's probably okay. Trademarks. Now now you all know all about trademarks because you read the booking.com case and wrote excellent, really good case briefs on them, right? I haven't read them yet. They're really good, aren't they? Right? Okay. I'll take your word for it. So the Lanham Act, that's trademarks, right? That was passed in what, 1946 or something like that. And trademarks apply to any kind of unique packaging, color combinations, overall presentation of a product, or trademarks. And you can trademark, basically there are 4 types they identify, the book talks about here. You've got fanciful or arbitrary trademarks. Examples of that are like IKEA, Apple. You know, it's just sort of fanciful or arbitrary means it doesn't actually tell you what the product is they're selling. Apple isn't fruit. It's that laptop you've got there. That's, you know, Apple, but it's laptops and phones and stuff. So that's why is it called Apple? Well, it's got the little bite mark out of it. Looks cool. Everyone knows what it is now, right? So that's IKEA. What does that even mean? Who knows? The Swedish are very strange people. Suggestive. This is the second type. And then they like suggestive, they have like glance a day calendars. They give an example. I've never heard of that. But I guess it makes sense. Glance a day, look once a day, and it's a calendar. I guess that sort of makes sense. I can't think of any good examples of suggestive trademarks, but that's kind of that's the second level. Then you've got descriptive. And that's something like where they say world's best bagels. That's got to be something, there has to be distinctiveness. You have to have acquired distinctiveness, which means usually that it's been in commerce for 5 or more years and is very recognizable, you know, so it's whatever that world's best bagel or whatever, that company, they've been around selling bagels for years and years. And everyone knew, man, these bagels are great. And they've been saying world's best bagels for years. They can show that. They can then register that for a trademark and it'll be good. Now, if they just came in, you open a brand new bagel shop and you say, I want to trademark world's best bagel. And we're like, no, nobody's heard of your bagels. In fact, I tried one and it wasn't even that good. So we're denying your application. But you've been at it for a long time. You've established distinctiveness. You've created this kind of market for it. Then you can get it. And then 4 is generic. The book actually mentions the booking.com that PTO denied their registration application for the trademark. And they said, it's generic. Well, what did the Supreme Court think of that? Not generic, right? They're essentially basically kicked it up to that 3rd tier there of distinctiveness, right? Booking.com has been around long enough that people know booking.com is this particular website, you know, that's referred to as booking.com. And of course, the court also in that case was talking about generic.com is you know, it's not the same as just pizza, you know, pizza.com can be, if you got that .com can add a certain level of this, you know, distinctiveness to it. And then as far as, well, it's also trade dress. This is a much less important one, but trade dress is basically the overall image of a product in business. It's like the can of Coke, you know, Coca-Cola's logo might be trademarked, like the can of Coke or the box of Coke is that qualifies, like that's your trade dress, right? And again, do what? Yeah, well, now packaging can be trademark, but it's the overall, but yeah, I mean, it is packaging, but like the logo on Coke, boom, that's trademarked, right? But the overall appearance, like the whole package, like, yeah, so it is packaging, yeah. But it's the appearance of it. It's not, because like some things like I did trademarks for these moonshine sausages. Old Smoky did it with, who was it? It wasn't Swagger, Wamplers. Their trademark, they have these moonshine sausages you can buy around here. And it's, their trademark was, boom, the label says Wampler's Old Smoky Moonshine sausage patties, that label. The whole trade dress would be the whole cellophane wrapped around the styrofoam box that has the sausages in it. Like that would be your trade dress. This is how the product in its totality appears in the market. Does that make sense? Yeah. So in trademarks, now they have the Redskins case. Obviously, Redskins aren't around anymore, or the name isn't. The team is still around, for good, better or for worse. Pro Football Inc. versus Amanda Black Horse. And basically, the point of that case was what? That's 2015. Now, but what do they? What does the court say here about that? It's distinctive, but it's also disparaging, right? So essentially, they're saying you can't register disparaging marks, and that's this band. These Asian guys have this punk rock band or something called the Slants. Did anybody look up to see what happened with that one? I think they were denied. I didn't look it up. I'm pretty sure they were denied. They said, no, that's racist. He's like, but I'm Asian. And they're like, still racist. He's like, fine. No, the Slants trademark. But it's actually, in the Rust versus Sullivan case is what's, they kind of talk about it in that Pro Football Inc., the Redskins case, to basically say that even though the trademark office is a government program, and therefore you think, well, the First Amendment should apply here, and even though it's offensive, I can say, First Amendment, as long as I'm not shouting fire in a crowded theater, I'm good to go, right? No, the Rust versus Sullivan, the court ruled in that case, the government can determine the contents and limits of its programs, and they don't have to fund alternative programs to provide, for what they don't allow in the other program that they funded. They can fund programs and do it the way they want to without running afoul of the First Amendment. So that's basically trademarks in a nutshell. Does anybody have any questions about trademarks? Okay, patents. The final one here, I think, is the final one. Yeah, we know we have trade secrets as well. But patents are inventions, as you said, Don. That's essentially you've created some kind of product, some kind of new handy dandy. The toilet paper roll was patented. If you look up the patent, it's actually overhand the correct way. That's how it is on the patent. If you do it the underway, that's not right. I used to think it was the underhand, but then I saw the patent. It's overhand. It's there in the patent, but that patent's expired. So do whatever you want. But you cannot patent laws of nature, natural phenomenons, abstract ideas. The book talks about this guy wanted to patent his, he was going to set up like a hedge fund that was going to do all this unique way of buying and selling commodities. And they're like, yeah, it sounds great, but you can't patent that. Sorry, buddy. That's abstract. There was big deal over DNA. This company was able to isolate certain DNA sequences or segments that really helped. It was like did a majorly advanced cancer research or cancer treatments. I think it was. Remember, was it cancer or whatever it was? It was like these DNA segments. They could isolate these DNA segments, and that like it was a huge boon to medical research. But then these doctors and patients and all these people got together and said, you can't. These people have patented it, and they're making tons. They're making like $222 million. They made off of this stuff. And the court said, okay, you isolated the DNA. That's great. But a DNA segment is naturally occurring and you can't patent that. Now, if they'd gone in and tried to patent the way in which they isolated that DNA segment, you'd probably be good. That patent would have probably been fine because they've created technology to do that. They've actually invented something to find this natural phenomenon. But that's not what they did. They tried to just patent the actual DNA segment they found. They said, no, it's natural. You didn't create anything with this DNA segment. Therefore, you don't get a patent for it. Now, patents have the shortest lifespan. Well, trademarks, it lasts, I think, 5 years, but you can renew trademarks. You can constantly renew them. It's like 5 or 6 years, something like that, but you can renew them. Patents last 20 years. Copyright, life of the author plus 70 years. Trademark, it's 5, 6, whatever. I can't remember exactly what it is, but you can renew them. You can just constantly be renewing your trademarks. But patents, it's 20 years. And that's like with drug companies. That's what we were talking about earlier. With drug companies, they get to market this brand name drug. They've got it for 20 years, depending on when they get their patent and when they actually get to market. Maybe they're only market 15 years, but that patent will only last 20 years. Then it's expired, and it's if anybody can find that information, come up with it and figure it out themselves after the 20 years, they can do it. That's patents in a nutshell. Again, that's inventions, it's products, it's you've created some kind of something to make life more convenient. Toilet paper hung in a proper overhand fashion was patented. Obviously expired a long time ago, but not that long ago. And that's basically patents. Now, finally, trade secrets. Trade secrets, you don't have really any registration for them. They're kind of basically how they exist. The only way you can show or prove a trade secret is you've got to have, there's got to be some economic value derived from the fact that this trade secret is not generally known. The key is in the name, it's a secret. And there's got to be some economic value attached to its secrecy. And you have to have taken reasonable steps to keep it secret. Can anybody think of any examples of a trade secret?
WD-40.
WD-40? Yeah, people say it's fish oil. It's not fish oil. But yeah, WD-40. Coke is a big one. That's a major one. KFC, 11 herbs and spices. Like they got it's written on a piece of paper and they keep it in a safe and they make a big deal out of, they'll fly it out from Fort Knox or wherever with armed helicopters and crap. But hey, it's, that chicken's delicious. You can't deny it. I mean, it's not the most delicious chicken, but it's still pretty good. And it's a unique recipe. Its value comes from this unique combination of ingredients. So yeah, KFC, Coke, WD-40, those are examples of trade secrets that, and that's indefinite. As long as you've kept it secret, you've got that protection. Now, if you just let people walk in and someone comes in and just takes a picture of the Coke recipe, the president of Coke is like, did I leave that recipe laying? Oh, no, he didn't take reasonable steps to protect it. You've lost it. No trade secrecy, no trade secret protection. Of course, that does play into issues we've had with the theft of intellectual property in this country in the past couple of decades. There's a lot of reverse engineering as an example of how they can engage in the theft of trade secrets and of patents. They actually did pass the Defend Trade Secrets Act of 2016. That specifically the first time they really codified trade secrets and making it, illegal from a civil standpoint, not criminal, for people to steal trade secrets, because you take all the reasonable steps in the world, people can still might be able to get to it. You're not getting a Coke or KFC. They keep that stuff locked up, but reverse engineering is a big way that people can do that. Now, people haven't been able to reverse engineer Coke or KFC, but with certain products, it can be much easier to do that. And that will happen quite a bit. So actually that Defend Trade Secrets Act of 2016 did make reverse engineering specifically as something, illegal or actionable as a violation of trade secret laws. And then finally, we've got the PepsiCo versus Redmond case. That's where Redmond was a high up executive for Pepsi for 10 years. Quaker owned Gatorade. I think, does Pepsi own Gatorade now? Did they buy it? I don't know. But anyway, at the time, Quaker, 94, whenever this was, Quaker owned Gatorade, and obviously Gatorade's the major player in the sports drink market. Redmond leaves Pepsi and he wants to go work for Gatorade, and he knows all the ins and outs of how Pepsi, formulates their drinks, how they market them, how they sell them. And Pepsi sues and says, hold on, this guy, it's what's called the inevitable disclosure theory or rule, whatever you want to call it. They said there's just no way this guy was so heavily involved in the upper management, in the highest levels of production in Pepsi. He was in California, and it was like 20% of Pepsi's market was under his control, I guess you could say. And they said there's just no way that he's going to be able to go to Gatorade and not, disclose our trade secrets to Gatorade and make them a bigger, because Pepsi at the time had a competitor drink to Gatorade. They're like, there's no way that this guy is not going to disclose our secrets to Gatorade. And the court says, you're right. He definitely, there's no way he'd do it. So what they do is they say, well, what did they say? You can't work for Gatorade until 95. It was like 94. They said you can't work there for a year and you can never disclose Pepsi's trade secrets. Of course, it's kind of inconsistent ruling. We say there's no way he's going to avoid telling these trade secrets. So you can't work there for a year and you can never tell him the trade secrets. Like we just said, there's no way I'm going to be able to avoid telling him the trade secrets, but maybe you'll forget after a year. Who knows? Does that seem fair to say, hey, you can't go work for this competitor? Is that kind of, it's like impeding his ability to go earn money? He probably already made a lot of money though. You want?
I don't know what the year adds to that. Like he can go work, is he gonna be less likely to tell a trade secret in years?
Yeah, it seems like he'd be more bitter, and just be like stewing over it for a year. First thing he's going to do is march in. But, when you've got a court order against you saying you can never disclose these trade secrets and it comes out you did, you'd be a lot more than just financial liability for disclosing the trade secrets. You could potentially have contempt of court issues. So you might end up going in the slammer for a little bit. But there's a question of, should Pepsi have rehired him if that was going to be? I don't know. That one seems pretty bad too. It's like this big lawsuit. Okay, we're going to rehire you, but everyone's super bitter. Everyone's so bitter. Like, you guys, I had to pay a lawyer a bunch of money, and we had to pay a lawyer a bunch of money. And then the lawyers are laughing all the way to the bank, right? So yeah, should Pepsi have had to have rehired Redmond? No, I mean, the guy can go get a job somewhere else. He doesn't have to go work for Gatorade. But when you get into that high level, all he knows is the drink world. That's all he can do. That's all I can do, Your Honor. I don't know. And then questions of commercial morality there. Should this guy have been going to get another job? Well, maybe Pepsi wasn't paying him enough money. I don't know. But that's trade secret. It's, again, pretty simple. There's got to be commercial value associated with this. There's got to be some economic value derived from its secrecy, and you've got to take reasonable steps to protect it. And that's basically it. We've gone through, I think, pretty much every chapter of the book. We didn't skip any. Did we skip any? No, we went through every chapter of the book. We made it somehow. You all got emails for course evaluations. They want you all to fill those out. I don't think I'll ever see them, but so feel free to say whatever you want. His jokes were terrible. Didn't learn anything, and I won't be able to argue with you. But enjoyed having you on for class. Again, final exam Wednesday, due by 8 p.m. So start it by 5:30. And you can study with each other, but you can't take the exam with each other. It's open book, open note, but no Google and no Wikipedia or any of that stuff, just the book and the notes. I would advise you to study. If you try to just whip out the book, start the exam, all right, let's get this thing going. You might get through 20 questions and then you'll be out of time because you spent it all reading, rereading, right? Because you've all read the book, and we all know how long it takes to read this book. So still have to do discussion posts. Don't forget, by Friday, that's gonna be the last thing you have to do is discussion posts. That'll give you another 50 points participation. If you don't do it, you'll get 0 points participation. So your grade will go down accordingly. So do the discussion posts. Final exam, any questions, you all ask them now or text me or call me later. Everyone, it's been great. And I thought we were going to have one more class. I was wrong. So this is it. You've been great. Good luck on the exam and Godspeed. I guess I should have given you a chance to